The House will come to order. Members will be at their seats. The clerk has opened the roll, and you may record your presence. Please rise and give your attention to our House chaplain and remain standing for a pledge of allegiance led by Representative Shue.
Let us pray. Lord God, we thank you for your faithfulness and mercy in being with us each and every day. Your word tells us that you bestow favor and honor. No good thing do you withhold from those whose walk is blameless. Today, I do ask that you show favor upon these leaders as they conclude all the business before them. Give them clarity and cohesiveness as they make final decisions. One more thing I ask of you, and you know how difficult this is for me to ask, but I want to be Christ-like and take the high road. So I'm asking that you be with the Jayhawks this weekend. Help them to play hard and smart and to represent Kansas well. In Christ's name I pray, amen.
Amen.
April Fools. April Fools.
Have all members had the opportunity to record the presence? The clerk will close the roll and record the attendance. Introductions of bills of concurrent resolutions, the clerk will read.
House Bill number 2748 by the Committee on Federal and State Affairs, an act concerning health and health care, enacting the No Patient Left Alone Act, requiring hospitals and other health care settings to allow in-person visitation of patients or residents.
Are there announcements? Representative Woodard.
Thank you, Mr. Speaker. Democrats, surprise, surprise. We will have agenda immediately upon recess in room 152 South. Thank you, Mr. Speaker.
Any other announcements? Majority Leader Hawkins.
Thank you, Mr. Speaker. Republicans, we will calendar in the old Supreme Courtroom upon recess. Mr. Speaker, I move the House recess until 11 a.m.
You've heard the motion. All in favor signify by saying aye. Opposed, no. We are in recess. The House will be in order. Message from the Senate. The clerk will read.
Senate adopts conference committee report to agree to disagree on House Bill 2106 as appoints Senators Tyson, Peck, and Holland as second conferees in the bar of the Senate. The Senate announced the appointment of Senators Olson, Hildebrand, and Faust Godot to replace Senators Longbine, Fagg, and Holscher as conferees on House Bill 2136.
Speaker recognizes Representative Landwehr on a motion to adopt the conference committee report on Senate Bill 200.
Thank you, Mr. Speaker. Senate Bill 200 was to amend the Pharmacy Act to include a point-of-care testing and treatment for certain health conditions, and those are influenza, strep, and urinary tract infections. Senate Bill 200 passed the Senate on 3/23 with 21 to 16. It passed the House on 3/3/22, 116 to 18. Also included in the conference committee report is House Bill 2253, which was not brought up above the line in the Senate. And this is a bill that came from the Social Services Budget Committee, and it's something we wanted to make sure it got passed, and it deals with some modifications and tweaks on the K-TRACS prescription program. I'd be happy to stand for questions.
Is there discussion? Representative Ruiz.
Thank you, Mr. Speaker, and I urge your vote on this, on Senate Bill 200. Thank you.
Any further discussion? Seeing none, Representative, you may close.
I move adoption of conference committee on Senate Bill 200, and I close.
This constitutes action on Senate Bill 200. The clerk will open the roll, and you may record your vote. Final action. Has every member had an opportunity to record the vote? The clerk will close the roll. Does any member desire to explain his or her vote? Does anybody desire to change his or her vote? Representative Ballard votes aye. Further changes? With 112 voted in favor, 2 against the passage of Senate Bill 200, the same had received a constitutional majority. The bill is hereby declared passed. The clerk will record the vote. Speaker recognizes Representative Landwehr for motion to adopt the conference committee report on Senate Bill 343.
Thank you, Mr. Speaker. The conference committee report on Senate Bill 343, the House voted on this bill on 3/21/22 with 122 to 0. The Senate had it on 2/15, 39 to 0. This replaces, it deals with hearing impairment in similar terms with hard of hearing, hearing loss, or deaf, and would, among other things, prohibit blindness from being a determined factor, being a determined factor of for denial or restriction of legal custody, residency, or parenting time when it's determined otherwise be in the best interest of the child, and this would also include foster care. We also have in this bill Senate Bill 276. That bill passed on the Senate floor 40-0. It did not get brought above the line in here, but this bill was brought to us by the Kansas Commission for Deaf and Hard of Hearing, as well as a private citizen, to change the definition that we currently have in statute of hearing impaired to hard of hearing. They felt like impaired means that they're broken. I'd be happy to stand for questions.
Representative Ruiz.
Thank you, Mr. Chair. I believe our chair of our committee did a really good job of explaining the two, and I think we were really happy in our conference committee to be able to add in the issue about visually impaired and foster parenting. I urge you to vote yes. Thank you.
Further discussion? Seeing none, Representative, you may close.
Thank you, Mr. Chairman. I encourage you to support Senate Bill Conference Committee 343 and move adoption. I close.
This constitutes final action on Senate Bill 343. The clerk will open the roll and you may record your vote. Has every member had the opportunity to record their vote? The clerk will close the roll. Does any member desire to explain his or her vote? Does any member desire to change his or her vote? With 115 voted in favor and 0 against the passage of Senate Bill 343, the same having received a constitutional majority, the bill is hereby declared passed. The clerk will record the vote. Representative Landwehr for motion to adopt the Conference Committee report on Senate Bill 453.
Thank you, Mr. Speaker. Conference Committee report on Senate Bill 453 let's see here just a minute. Amends law concerning the completion of 40 hours of training in basic resident care skills for unlicensed employees that work in adult care homes. For many of those of you that are familiar with how care homes work, the issue that they've been struggling with a lot of shortage on those homes. They were allowed during the pandemic to have what we called TAs, which were temporary assistants. This will put in statute a definition, allow them access to training, and to be able to eventually complete their CNA certification. 453 passed the Senate on 223, 40 to zip. Passed the House 321, 122 to 0. The next bill that we have in there is House Bill 2734, which was a bill brought to us by the BSRB to make some modifications in licensure requirements in order to put us more in line with some of our other states across the country, as well as allowing us to get more social workers out there, because as you all know, we have a shortage of that. That bill passed on this floor 321 at 122 to 0. Be happy to stand for questions.
For discussion, Representative Ruiz.
Thank you, Mr. Chair. Again, the chair of our committee did a great job of explaining the two bills, and you know this is really important for us in Kansas. We need more social workers and we need more healthcare workers, and this would help us be able to add more folks, but add them a little bit more quickly, and being able to have like the CNAs have more of a career track so that they can, if they wanted to, become RNs at some point. So really important bills. I urge your vote. Thank you.
Is there further discussion? Representative, you may close.
Thank you. I move adoption of the Conference Committee on Senate Bill 453 and ask for your vote, and I close.
This constitutes final action on Senate Bill 453. The clerk will open the roll and you may record your vote. Has every member had the opportunity to record the vote? The clerk will close the roll. Does any member desire to explain his or her vote? Does any member desire to change his or her vote? With 116 voted in favor and 0 against the passage of Senate Bill 453, the same have received a constitutional majority. The bill is hereby declared passed. The clerk will record the vote. The Speaker recognizes Representative Ralph for a motion to adopt the Conference Committee report on Senate Bill 286.
Thank you, Mr. Speaker. This matter comes to the body. This is House substitute for Senate Bill 286. Body, as you'll recall, this bill came across our floor, was passed out 102 to 17. It came across our floor with a couple of floor amendments. This bill deals with the expansion or extension, if you will, of government response to the COVID-19 pandemic. I'm going to hit just several of the highlights. There's enough stuff going on in this bill that I want to leave significant time for folks with questions on this. But so if I go through this rather quickly, if there aren't questions, I'll come back and expand a little more. Well, I'm sure representatives from Sedgwick County will deal with some of this as well. The provisions in this particular bill are going to do several things. For example, expanding our telemedicine availability, expands the use of hospital beds and non-hospital space. We expand and extend immunities for liability for healthcare providers related to the COVID-19 health emergency. We also expand immunities for the, business claims related to COVID-19, and it also contains some provisions related to retroactivity of these provisions moving forward onto January of 2023. There is also within this particular bill, there is created a crime of interference with hospital performance. As you recall, that was also a part of the bill as it was on our floor. In conference committee, we made a little bit of an amendment to that particular provision related to identifying more specifically what is referred to as restraint within that bill. This particular legislation within conference committee required multiple meetings and quite a bit of an opportunity for lawyers on that particular committee to work pretty significantly with language, trying to find resolution for this between the House and the Senate. I will tell you that it wasn't a significant amount of assistance from the Senate, but would like to also thank the revisor's office because we went through quite a few revisions of language and quite a few balloons, and this took quite a bit of effort to get to a spot where both the Senate and the House could come to an agreement to bring this matter to you here today. At this point, I'm going to go ahead and stand for questions, Mr. Speaker, and I'll make some additional explanation if necessary.
Representative Carmichael.
Thank you, Mr. Speaker. A question or two for the carrier of the conference committee report. Good morning, Mr. Vice Chair.
Good morning.
I do not see the smiling face of our chair this morning. I don't think that he's intentionally abandoned us, but I think just out of curiosity of the rest of us, perhaps it would be important to explain that our chairman has a prior commitment, and I'll let you explain, but I don't want people to think that the chairman has fled and run.
Not at all. And a long-standing commitment that the chairman had in relation to some, as people might know, many other duties that he has civically around this city and around the state. And he had a prior commitment to professional commitment, long-standing for a couple of years. I'm quite certain that he got no sleep last night being able to catch his transportation to make that commitment today. And I wish him well and certainly don't anticipate that anybody would think that he abandoned us on this, although I will tell you he left me very strict instructions not to mess up his record on getting these things passed.
That's all I need. Thank you, Mr. Vice Chair. I just wanted to make sure everyone understands that our chair is as hard a working legislator as anyone that I know, and his commitment involves his prior service as a member of the school board. In fact, one of our members is also absent today to be at the same convention, and in fact, the chairman of House Judiciary I believe will be swearing in the new president of that national organization. So it's an honor for Kansas, and I believe it's an honor for the chair of House Judiciary. Those kind words being said, I now must unfortunately address with you some matters that are extremely serious and very sensitive. As I think most of you know, a bill was introduced by a member of my caucus that was designed to protect hospital workers from assaults. It was also designed to assist hospitals in obtaining prosecution of individuals who interfere with the activities of a hospital. Both of those actions are, in fact, matters that can be prosecuted under current and existing law. The tweak, if you will, that was contained in the bill introduced by a member of my caucus was to increase the level of severity for that misdemeanor offense. It did not result in an impact on bed space. What that means is that adoption of the bill that was offered by a member of my caucus would not have put anybody in jail for any longer. But it was certainly requested by the Kansas Hospital Association. I commend the member of my caucus who did the hard work to get that bill to the floor and to get that language incorporated in SB 286, and she did it so well that only 17 members of this chamber voted no. But the manner in which that bill was handled was a manner in which the bill was held hostage. The bill did not rise above the line, but instead, at turnaround, was blessed by one of the most unusual references that I've encountered in my time here. It was sent to Calendar and Printing. That is a committee where oftentimes bills are sent to die. Then one day, the bill suddenly reappeared along with Senate Bill 286. Senate Bill 286 was amended on this floor to dramatically expand the immunities that were granted to hospitals by legislation that we passed 2 years ago. That original legislation was the product of excellent work, excellent bipartisan work by leadership in this chamber, members of the minority party, and the governor's office. That compromise language has served us well for 2 years in a time of severe crisis. At the time that original legislation was passed, the words of the Speaker pro tem were eloquent. They still reverberate in my mind. Unfortunately, the Kansas Hospital Association was not satisfied with that compromise language, and they demanded more of us. Accordingly, an expansion of their immunity was incorporated in the original version of 286 that passed the House. The work of my colleague, to protect nurses and hospitals from interference was held hostage as the price for passing the expanded immunity demanded by the Hospital Association. Why, you might ask, did the Hospital Association demand expanded immunity? They were courteous enough to talk to me about the situation in advance, and I told them that I was not going to be able to support their proposal. My conclusion from those communications with them was that they were very concerned that they were going to be sued over matters related to ivermectin, hydrochloroquine, and other forms of treatment for COVID, as well as vaccination status-related matters. And that fits because, so far as I know, there haven't been any lawsuits over COVID and health care providers. And so the bill proposed to protect the hospitals, proposed by my colleague from my caucus, was held as the price for the expanded immunity so as to obtain Democratic votes to pass that legislation, despite the objections of folks who believe that their rights regarding vaccinations and forms of treatment for COVID were being trampled. The bill passed. It went to the Senate. It then arrived in the Conference Committee earlier this week. I was absolutely perplexed as to why we couldn't just go ahead and pass the bill back out in the Conference Committee. It had the votes to pass this floor by a veto-proof majority. But instead, the bill stalled in committee for reasons that at the time seemed inexplicable. I was very upset, frankly, with my friend, the chair, and it's very seldom that he and I do get upset with each other. We tend to brag that that only happens once a year, and we thought we were going to get through it this year without it happening. Because I personally felt like the Senate was making reasonable counteroffer to us in view of the amendment that we had made on the floor. But I couldn't figure out why the House would not give a substantive response. It languished for better than 24 hours with no substantive response from the House. That's not the way we do things in the House Judiciary Committee. We do our work promptly. But for some reason, House Judiciary would not respond to the counteroffer made by the Senate. Then, amazingly, it became clear what was going on. Because suddenly, House Bill 2387 also arrived on the scene of the Conference Committee as a gut and go to include legislation extremely favorable to the incumbent managed care organizations, or MCOs, that operate the CanCare program. In short, that legislation gave them a no-bid extension of their existing contracts. As soon as that gut and go was offered by the House over my objection, progress was immediately made on 286. Additional tweaks were made. Many lawyers, much brighter than I am, actually believe that those tweaks may have expanded the immunity given to hospitals and other healthcare providers to the extent that it goes far beyond even COVID-related matters and could result in essence, a prohibition against most medical malpractice litigation for injured patients over the next 10 months. Now, whether that is correct or not, I'm not wise enough to render that opinion, but lawyers who are much smarter than I am say that that may well be the impact of what we did. Why am I taking so much time with you on this? We will discuss HB 2387 as gutted and gone probably later today, and we will talk about that on the merits. But the way it ended up and why 286 was held hostage in the conference committee may well relate back to matters which started in 2014. I was here at the time. The stench of pay-to-play politics permeated our Capitol. Legislators' phones were being tapped by the federal authorities. Members were afraid to talk to friends because pay-to-play politics was the allegation being made against this legislature, as well as our then governor. That did not result in indictments. But I'm sure I'm not telling you things that most of you don't already know. Rumors of subpoenas have once again permeated this State House. Subpoenas related, sadly, once again, to pay-to-play politics. I commend the Kansas Chamber of Commerce for what they did today. According to the Kansas City Star, they confirmed that, in fact, subpoenas are afoot once again. The stench of pay-to-play politics has returned. The HMOs were arguably implicated in the events that happened in 2014. And I would suggest the pattern that we see now leads to that same conclusion, that the MCOs are attempting to improperly influence this legislature. So, even before this bill was held hostage, it had serious problems based upon the amendments that were made on the House floor, and it only got worse in the conference committee. So there's plenty of reason to vote no on this legislation, separate and apart than the manner in which it came before this House. We don't want to live in this Capitol or in this state under the power of pay-to-play politics, and a vote in favor of this conference committee report is an endorsement of pay-to-play politics. So as for me, I will be voting no on SB 286, the conference report. Thank you.
Representative Featherston.
Thank you, Mr. Speaker. Mr. Speaker, I would like to make a substitute motion to send this conference committee report back and that a new conference committee be appointed.
This is a debatable motion. Anyone like to speak to the motion? You still have the floor.
Thank you, sir. As I talk to friends on both sides of the aisle in this chamber, I hear the phrase a lot, can't we just do one good thing without messing it up? Can we not just stand for the people and for what is right once without linking it to something that causes so many of us distress. Today, I am taking that privilege to stand up for the 70% of emergency department nurses that report being attacked at work, for the nearly 50% of emergency department physicians that report being assaulted at work. I stand with these workers by asking this bill to go back and be reverted to its original form of House Bill 2260. I ask you to think long and hard about who you want to stand with today and where you feel about things being linked together that cause you distress. Thank you.
We'd like to speak to the motion. Representative Ralph.
Thank you, Mr. Speaker. I appreciate the comments of the prior representative, but a couple of points that need to be understood very clearly and very specifically in this circumstance. First off, in reference to the doing one good thing, I think it's important to keep in mind and remember the chair of the Judiciary Committee at the end of most sessions that I've been here has been placed in a position where he has saved multiple pieces of legislation that I think most everybody in this chamber would categorize as good, and has saved them only because he's been able to put them together with other pieces of legislation. So let's please don't lose sight of the fact that the representative is considering one piece of legislation, but we're trying to save multiple pieces of legislation from what I'll call the delaying tactics from the Senate. In this particular instance, please keep in mind that as we embarked upon this conference committee with the Senate, the very first position they took was to remove the provision related to interference with hospital operations completely. They struck it. And it was saved in this particular legislation only based upon the solid position taken by the chair of the Judiciary in supporting the House position in that regard. We must believe that if this matter were to be sent back, there would be nothing else to be gained, and that very likely the Senate would revert to their position, at a minimum, would revert to their position of removing the interference piece from this legislation with no explanation whatsoever. Because I will tell you, we had no explanation whatsoever in committee in that regard. So at this point in time, what I must request that you do is oppose this motion to send this back. This matter right now is the result of multiple hours of an attempt to keep very good pieces of legislation, including this particular piece. And I'm afraid that if this goes back, all of this would be for naught. Thank you, Mr. Speaker.
Any further discussion? You get a close, but any further discussion? Seeing none, Representative, you may close.
Thank you, Mr. Speaker. This time I'd like to remind you this bill had bipartisan support. You can look up the co-sponsors' names. Those co-sponsors were involved with law enforcement, medical community, and those who wish to stand with the medical community. The original bill was supported by law enforcement, the Hospital Association, the district attorneys, countless doctors, nurses, other hospital workers. I close my motion.
For the motion, all in favor signify by saying aye. Aye. Opposed, no? No. Noes appear to have it. Division has been requested. The clerk will open the roll. You may record your vote. Every member had the opportunity to vote. Clerk will close the roll. 46 in favor, 66 against. The motion fails. We are back on the adoption of the Commerce Committee report. Anybody else like to speak on the report? Representative Humphreys.
Thank you, Mr. Speaker. Could I just ask a couple of questions? So this I think is a question several people have had. Can you just point to us where it, because we know the previous order, the previous bill expired yesterday. So explain to us how we renew something when it's actually already expired.
This was and is a concern, has been a concern as we went along because of the expiration dates. The language that you will find within 286 provides provisions that we intend to create retroactivity for all of these immunity provisions. And folks, please keep in mind, you've got involved in this immunity provisions, and then you have some specific provisions that are restrictions on those immunity provisions, and I've lost the word that I'm thinking, exceptions to those immunity provisions. So there can be some language difficulty of trying to keep these straight. But then we also add in, there is retroactivity provisions provided in here that talk about, to the extent that we can, we are providing within this language that all of the immunity and the exceptions to immunity will be retroactive to the initial date of this, and keep in mind, because we did have a question earlier, these refer back to a starting point, and we included in the original legislation a starting point of March 12, 2020. So the retroactivity provisions, and if you were listening in on any of the conference committees, the revisor's office, and there were significant discussions about whether in fact we were able to create retroactivity, how the court would view that, and whether we could get retroactivity all the way back to the beginning, and also whether we could create, in essence, what I'll call a bridge for these potential points in time that between the expiration on March 30th or 31st and potentially the passage today. Did I get close?
Yes, and so I do have a question. In the brief, which I printed because it's easier than looking at it electronically, it says that on or after March 30th, 2022. I mean, there's a date of just going back to March 30th. Now, this is the brief. You're looking at the bill. Is there...
I'm going to guess that may be...
This.
And in the brief, we may have that may be a typo on the 2022, because I'm not aware of that date showing... Sorry, Bonnie. But we're talking about a section on the bed usage, access to hospitals, and a date in there. And I haven't specifically looked at that. I certainly can look at that piece or section, because I thought I was focusing on the concerns of the immunities and the exceptions.
Okay, I don't see the bed uses in here. I'll take your word for it. But okay, and then just. Another question. So the immunity doesn't apply to healthcare providers if they deny healthcare services to a person at the medical facility based on that person's COVID vaccination status. So can you explain a little bit about what healthcare services means? Is that going to be just in the emergency room? Is it going to be, we're going to go ahead and do surgery if you need it? You can schedule surgery, an emergency surgery or even a planned surgery. If you could just help us understand what you mean by that.
Healthcare services would be what you would consider to be a pretty all-encompassing term in this particular regard. In there we talk about healthcare provider. Those are defined, but the healthcare services are going to encompass pretty much anything that you're going to talk about, because what we go on to say there, as you read through this exception to the immunity, we're talking about if that denial is made based solely on that person's COVID-19 vaccination status, and this deals with doctors who are employed by a, and I'm going to use the generic term hospital, or the hospital. And if they deny solely, the services solely on the basis of that, then they don't have any immunity. Then they are just subject to the normal responsibilities and liabilities that may occur in any circumstance of providing healthcare services.
Yeah, thank you. That helped answer that. And then just my last question. I mean, it's maybe more of a comment, but you can comment back. In Judiciary Committee, when we heard about the battery against healthcare providers, and I mean, it just so many testimonies that went on, and that was very persuasive. I think the more heartache is about the interference with the conduct at the hospital. I mean, I'm just thinking of the times that my kids were in the emergency room and how I acted as a mom and different things. So could you comment on maybe to what extent are we talking about interference? Because we all have those instincts that we might want to protect our people.
I think the best explanation I can give you would be in any circumstance within the hospital facility, those are going to come back down to factual circumstances on a case-by-case basis. And ultimately, there's going to have to be an initial discretion used by law enforcement, and then potentially, again, by county attorneys or prosecuting attorneys, by the facility itself, or ultimately by a court. There are going to be times where, by definition, we won't be able to tell you specifically in any particular circumstance, this is going to fit and that won't fit. I think what we're, and as you heard in committee as well, what we're trying to do in these circumstances in many instances is, I'll use nurses as an example. A nurse may be confronted, battered, whatever in those circumstances, and to pursue something in those instances falls upon that particular employee. This also provides the opportunity for a facility to actually act for those employees in the pursuance of these particular, pursuing the crime or advocating for the employee, rather than the employee having to shoulder that entire burden themselves. So I know I didn't get specifically to an answer to your question, but.
Yeah, that was helpful. Thank you. So, Lottie, I know that the Judiciary Conference Committee has worked so hard this week on this, and there's been delays, and there's been this and that, and I find this a hard CCR to vote for. I don't know what I'm going to do yet, but the reason I'm saying that is because there's good things in it, and there's things in it that I don't agree with. I'm not crazy over the expanded immunity, and but some of the business immunity, there's other things, and I'm just offering that we all know it's hard. This is a process. Do what you think is the right thing, and I have hopes at some point we can have a more transparent process, but that's for another day. So at this point, I really appreciate your work and everything that y'all did this week.
Representative Hauser.
Thank you, Mr. Chairman. Can you hear me in the back row? Boy, it's a miracle because I'm winded from running down that aisle that fast. And I'm winded because I caught COVID and it knocked it out of me. And that's one of the reasons here that I want to talk down to you here today. I'm not going to be supporting this bill, and I'm going to tell you why. It protects the hospitals, and it protects the healthcare workers, but it doesn't do anything to protect those brave doctors and nurse practitioners who are prescribing off-label uses for ivermectin and hydrochloroquine. I'm going to tell you a little story, and just bear with me, because you'll see where I'm going. Day one of session, I'm here, feeling great. That evening, I started getting a scratchy throat. And I knew that I'd been exposed to COVID virus the week before. So I called up and I said, hey, I'm going to take off till I see what's going on. So the first thing I do is I immediately call my healthcare provider, which is not a private practice anymore. It used to be, but the doctor retired, and then a hospital across state line bought the bought it, turned it into a clinic, and was using nurse practitioners. So the first thing I did was I said, hey, I think I'm coming down with COVID, and ivermectin and hydrochloroquine had been proven to lessen or prevent the disease from, or if you want to call it that, the virus, from taking you down. So I said, I would like to have that. Well, we can't give that to you. I said, why not? Well, because it's against the hospital protocol. I said, oh, okay. So what can I do? What can you do for me? Well, we can tell you to take over-the-counter drugs, to treat your symptoms, and if you get feeling bad, go to the emergency room. I said, oh, all right. So I started looking for another doctor that could prescribe what I thought, because I put great faith in that medicine. It's cheap. It's proven to work. So anyway, in all of Cherokee County, couldn't find anybody that would prescribe it. So I found somebody out of county that would prescribe it. By the time I found him, I was like into day 3, and he says, yes, we're doing teleconferencing, having appointments over the phone, and we can prescribe you ivermectin or hydrochloroquine, and we will. So I said, fine, hook me up. So they were going to do it on a Friday. We're going to have teleconference on a Friday or a Monday, one or the other. Friday came, nothing. Monday came and went, nothing. Hadn't heard from him. So I kept trying to call him back up, say, hey, what's going on? You know, we were going to have this teleconference. And now I'm on day 7, okay, of symptoms. Yeah, day 7. So my good buddy that hooked me up with him in the first place, he called him, and I got an appointment the next day. Well, it come to find out that the reason that I got bumped off those lists is because they quit doing that list, is because they were complained against to the Board of Healing Arts by local doctors and local hospitals that were not prescribing ivermectin and hydrochloroquine. So their attorney said, maybe you better lay off and not do that. So I fell through that gap, and I firmly believe that if I had not fallen through that gap and I'd had somebody that would have prescribed that for me early on in the stage, I wouldn't have missed 3 weeks of session. And I still wouldn't be huffing and puffing when I walked from my truck to the elevator. So I'm voting no on this. You know, I agree with protecting the hospitals and the practice, but if we can't protect, there's bills that pass the Senate side. You know, whenever I first got sick, Tuesday, the next day I called down here when I couldn't get the prescriptions, and I started a revisor working on me a bill. And come to find out there's about a dozen of them on House side. And there was 2 or 3 I know of on the Senate side. Some of those passed. Nothing. We heard nothing on this side about protecting those doctors that were willing to prescribe off-label medications. Nothing. And I know that there's a bill sitting over here that passed that side of the house, that side of the building, and we're just sitting on them. We're not doing anything. So for that reason alone, if we can't protect those doctors that are trying to help us and are getting persecuted and shut down, then I'm out on this one. Thank you, Mr. Chair.
Representative Burris.
Thank you, Mr. Speaker. Thank you, body. I definitely support parts of the CCR, protection for businesses, the part that says certain healthcare providers who deny services on the basis of a person's COVID-19 vaccination status won't enjoy the immunity provided for. I support aspects of the proposed new crime, but I'm very concerned about parts of this CCR. I remain concerned about the amendment brought on the House floor that significantly expanded healthcare providers' immunity from civil liability. I'm still not convinced that it's necessary, and it seems to me that we can continue to operate under the language we have been operating under for some time now. Also, the determination as to what is or is not COVID-related, it seems to me a hospital or healthcare provider has a significant degree of power over determining. Also, it came to light in calendar that if a person believes they were discriminated against on the basis of their vaccination status, they basically have to get an attorney. So I'm not sure that there's really enough protection there. Now, as I said, I support certain aspects of the proposed new crime, definitely. And I definitely want to protect our healthcare workers. It's very important. I sit on House Judiciary, and I heard some of the testimony that was given, and it was harrowing what some of the healthcare workers have gone through. And I definitely, obviously, condemn, like everybody else, violence perpetrated against healthcare workers. But if healthcare workers don't treat patients right, which can happen, that is a problem. Turning to the elements of the proposed new crime, which I assume all the element. I assume this element that I'm about, a particular element that I'm concerned about, is still in the conference committee report. And basically, if I may, I would like to read the element of the crime I'm concerned about. It says, interference with the conduct of a hospital is, among other things, knowingly refusing to leave a hospital upon being requested to leave by the employee charged with maintaining order in such hospital, if such person is committing, threatens to commit, or incites others to commit any act that did or would have completed disrupt, impair, interfere with, or obstruct the mission, processes, procedures, or functions of the hospital. I can think of scenarios where a family member is trying to support a loved one who is hospitalized and may get frustrated by how their loved one is being treated, but not take any physical action towards healthcare workers, but just maybe raises their voice or expresses disapproval of how their loved one is being treated. So, for example, if an elderly couple goes to the hospital, the wife is sick, maybe has COVID, they're not sure, the wife is admitted, is placed in a bed. The wife has to use the restroom, but needs assistance from hospital staff to make it to the restroom, and the hospital staff doesn't get there in time, and she unfortunately has an accident, and then the hospital staff gets there after the fact, and the husband is frustrated about that and perceives that the hospital staff is handling his wife somewhat roughly. If he were to raise his voice and express some amount of frustration or anger about it, and the hospital staff felt threatened by that and asked him to leave, and he did not leave, and they had to devote more staff to dealing with him, I think this language could apply, because it could be argued that he at that point is disrupting, impairing, interfering with, or obstructing the mission, processes, procedures, or functions of the hospital. Another scenario that I could think of would be a male aged in his 60s who has Parkinson's. It's my understanding Parkinson's patients typically are on a lot of medication, and it's extremely important that they get their medication on time. The correct medication, the correct dose on time. And if that does not happen, they can be messed up for the rest of the day, the week, in a lot of pain, a lot of other negative effects. If that male needs to go to the hospital, he's probably going to bring his medication with him. Now, it's my understanding that in that sort of a situation, I can't speak for every hospital. I'm not an expert on this, but it's my understanding that many hospitals will require that the medication be handed over to the hospital staff, so either they can administer the medication to the patient, or they, through their pharmacy, basically administer the same medication that the patient otherwise would have been taking. Now, if the hospital staff is unable to get this Parkinson's patient his medication on time, and let's say his wife is with him, and the wife gets frustrated by that, raises her voice, objects, says, hey, he needs his medication, doesn't get physical with the staff, just expresses a significant degree of frustration, and they feel threatened by her, and they ask her to leave, and she does not leave. Is she disrupting, impairing, interfering with, or obstructing the mission, processes, procedures, or functions of the hospital? I guess alternatively, if she were to not provide the hospital, if the wife was not to provide the hospital staff with that patient's medication and were to help this Parkinson's patient who's in the hospital, if the wife were to help him take his medication behind the scenes, and the hospital staff found out about it and said, you need to stop doing that, but she didn't want to stop because she wanted to make sure he got his medication on time, is she disrupting, impairing, interfering with, or obstructing the mission, processes, procedures, or functions of the hospital? An argument could be made. I can think of another scenario. A mother who recently had a baby. The baby's a few months old. The mother is sick, possibly with COVID. She's not sure. The baby is sick too. One day, it's getting bad enough to where the baby is having a lot of dirty diapers and not nursing well. And this is going on throughout the day and the night. And by 5 a.m., this mother doesn't know what else to do, so she goes to a major hospital in the Wichita area. She goes to the emergency room. She's there for 10 hours. She's a nursing mother, not given, and for the duration of the time she's there, she's not given food or water. An attempt to give the baby an IV to administer intravenous fluids is attempted. The IV equipment is placed on a dirty laundry container top. She notices this and points this out to the hospital worker who does get new IV equipment. There's an attempt to take a temperature, the baby's temperature, and a rectal thermometer is used. And the mother perceives that the rectal thermometer is inserted dangerously too far. She doesn't know how to deal with it. She's overwhelmed. She's exhausted, thirsty, hungry. And it's after another failed IV attempt, maybe sometime later, the mother comes to find out that the hospital staff determined that her baby doesn't need IV fluids, but she disagrees. The baby is still dealing with the same issues. Now, if it's, and she has to demand or at least strongly ask that, hey, my baby needs IV fluids. Can you guys do something about this? During this time, this 10-hour stay at the hospital where this mother is not given food or water and is dealing with various other issues, if she were to snap and express frustration to the hospital staff and they felt sufficiently threatened, perhaps she could be accused of disrupting, impairing, interfering with, or obstructing the mission, processes, procedures, or functions of the hospital. Now, I'm not saying that I don't know for sure what any given hospital or any given prosecutor in this state's going to do in the future. But the issue is I don't think anyone does. This language, I think, as an example, could be applied to any of the situations that I have just described. In other words, I think I support parts of this crime, but this part that I'm discussing, I just think is too broad and can be used to potentially punish wrongfully family members who are simply trying to do their best to advocate for their loved one while their loved one is in the hospital. So, Mr. Speaker, for those reasons, and thank you, body, for your attention, for those reasons, I ask that you oppose this CCR. Thank you.
Representative Landwehr.
Thank you, Mr. Speaker. I know that for the last couple of years, there's been a lot of talk about what a doctor will prescribe, what a doctor won't prescribe, who will prescribe it, who won't. And a doctor makes that decision themselves. A doctor today can find a pharmacy that will fill, whether it's the hydrochloroquine, I always pronounce that wrong, so it still may not be right, Dr. Epley, ivermectin, if they choose to find a pharmacy that will fill it. Some of the pharmacies have actually turned down because the prescriptions have been too high of a daily dose. So you can take it the opposite way. Off-label medications today are legal to be dispensed by a physician. So if the physician wants to have you on any one of those, they can do that out of their office. We have new drugs all the time that have been out there for a while that are actually being used. I found out the other day, we have an antidepressant that's being used for COVID. You just hear a lot about another one that's gotten the press all excited. And I think as far as the transparency is concerned, this conference committee was done online for the public to see. And the conversations you heard from the legislator that was just up here, if some of those things happened, that may be considered gross negligence. And from what I recall in the law, that will still be illegal action under this conference committee report. So I ask that you support it, please.
Representative Murphy.
Thank you, Mr. Speaker. Will the carrier answer a question or two? We were talking in the back a little earlier, and there are instances, I haven't seen it in Kansas, but I've seen instances where people have been denied the ability to get a transplant. They've been taken off the transplant list because they were not vaccinated. Is this covered? You've sort of maybe have answered that before, but I'm curious if...
Yes, circumstances of transplants or hospitals or facilities that do transplants, those were specifically part of conversations related to drafting of the language here. The language is specifically describing someone not being able to be precluded from treatment solely based upon vaccination status, because with transplant situations, there is a rather extensive rubric that is considered, as I understand, for transplant patients where myriad reasons are considered as to whether they are acceptable candidates or not. And so it's my understanding that in any of those circumstances related to transplant patients, solely vaccination status would not be one of the concerns in regard to the transplant situations, because there are multitude reasons that people have to fall within and able to qualify to be on those.
Yeah, I understand that, but these are people who had already qualified and were on the transplant list. So they'd fulfilled everything else. And it was so.
In those instances of anecdotal information, there'd be no way to respond to those because, frankly, I have no idea what those pieces would be.
So we're sort of like up to the courts and the attorneys.
No, that's not what I said at all. I described very specifically the language that's involved that would deal with circumstances or situations dealing with transplants.
But that's who would determine in the end.
Absolutely.
Right, that's what I was getting at. In a previous comment about the pharmacies, in my hometown, there are pharmacies initially that would fill those prescriptions, and in time, they all denied it. And so, while it may be legal and may be whatever like that, they were people who wanted it, who had been prescribed, had been denied. One more question I had was, it's mentioned about, in relation to this immunity, about if the doctor's doing standard of care. Who determines the standard of care?
Standard of care is always dealt with in any type of medical malpractice case, claims of medical negligence, or frankly, any type of professional negligence that becomes the subject of litigation is dealt with by determining whether you are practicing with a standard of care that is determined by bringing actual physicians, depending on the particular specialty that you're dealing with. You have to bring expert testimony that can state opinions within a reasonable degree of medical certainty, for example, if you're dealing with a medical case that establishes what standards of care are in any particular situation. So the medical profession, if you will, establishes that by their memberships. And as you might suspect, I haven't been involved in very many situations involving those cases where there certainly can be differences of opinion between doctors in that regard.
Yeah. And that's why typically we like to be able to get a second opinion. And the reason I'm bringing this up is lots of times we've seen, like with the WHO has a standard of care, the CDC has a standard of care, and a clinic may have one. Historically, doctors have been able to try to figure things out what's best for their patient. But with this particular instance, we seem to be following some guidance from on high and then offering them immunity when it doesn't work. And I can't support this, so thank you.
Representative Jacobs.
Thank you, Mr. Speaker Pro Tem. I'm going to vote no on this, and only because of personal selfish reasons. Saturday, I came back from doing a funeral on Friday. It was one of my aunt's funerals. My aunt and uncle were married for 60 years, 60 years and 5 months, because I called my uncle today to actually verify. My aunt was placed in the hospital with pneumonia, and she was tested for COVID, and she did not have COVID 3 days in a row. The story was kind of highlighted up here already by another gentleman, and the hospital staff was kind of negligent, and I know that we heard that there could be lawsuits, but honestly, 80-some-year-olds and 70-some-year-olds cannot find a lawyer. We can't even barely find lawyers right now to do this. Are these gentlemen who are lawyers going to do this? I doubt it. But we'll pass legislation to protect hospitals and give them immunity. But what about patient's immunities. My aunt, being 78 years old, was unable to get up out of the hospital bed, and she used the restroom in the hospital bed. The button was pushed for 20 minutes. My uncle went out to the hallway, found a nurse, and they began to, as he had said, not treated her very well. Jim was irritated about that. You know, with a man who, his best friend's in the hospital, unable to do, married for 60 plus years, he gets a little irritated. He's like, "You're not going to treat my wife that way." The next morning, when he comes back in, Mary is now positive for COVID. Jim's not allowed to visit her whatsoever. Later on that day, she goes into a coma. He can't visit her, he can't talk. The hospital said that they couldn't visit for 21 days. Well, Mary had passed away in there. As I mentioned, I did my aunt's funeral. I'm not voting for this. And this may be funny for some other people, but it's not funny to me. I've watched through this course of COVID, and I know this body probably gets tired of me, but I've watched through COVID individuals standing outside, men who fought in the trenches now having to look through window panes, nursing homes shut down and families not able to advocate for them. Now there's a suspicion that there was no one there really advocating for my Aunt Mary because my Uncle Jim was kicked out. This is very serious to me. I'm going to vote no. And I would ask that you would vote on the side of the people, not on the side of the corporations. Thank you.
Any further discussion? Seeing none, Representative, you may close.
Thank you, Mr. Speaker. Body, I understand the significance of feelings that people brought to the well today to speak in regard to this particular legislation. And so as I respond to it, it's going to feel a little clinical, and it's not my intention to do that, but I'd like to start out first off with this legislation passed our body 102 to 17 when it came across our floor. It contained the interference with hospital operations, and it contained the expanded immunities for hospitals and healthcare workers. In conference committee, there were created exceptions to those immunities. So the immunities were reduced from what we passed at 102 to 17 to bring this back for this conference committee report right now. I don't want to get lost in responding to every piece that came up here, but I do want to make just some very specific points back. I would certainly have loved to engage with the representative from Sedgwick County, but those comments were so long ago in this discussion that I'm going to pass those for the moment, but I didn't want the body to think they went unnoticed. The concerns about how people act within hospitals, if you act improperly in a hospital in some fashion that the hospital doesn't like, and they say stop that, and you don't, right now, under current trespass law, they will call or may call a police officer and you will be escorted from the facility, just as they would in a grocery store or anywhere else. That happens right now. That's the circumstance. This particular piece on the interference is specifically related to what our frontline workers are going through that they shouldn't have to go through. This particular immunity that is provided in this legislation provides and goes to any doctors, any healthcare facilities, treating
or refuse or not treating. Treating in a way that you think is appropriate or not thinking is appropriate. This protects all the doctors. There's nothing in here that says you have to treat a specific way. So the immunities go both directions for folks that are concerned about who doesn't have protection as doctors or healthcare facilities. I'm going to leave that at that particular point and just at this moment implore you that we pass this legislation at this point in time so that we can facilitate getting through what is now the remainder of this endemic in a reasonable and secure fashion. Mr. Speaker, I move adoption of the conference committee report for House Sub for Sub, Senate Bill 286, and I close.
This constitutes final action on Senate Bill 286. The clerk will open the roll and you may record your vote. Has every member had the opportunity to record their vote? The clerk will close the roll. Call House, seeing enough hands, the call is in order. Clerk. Doorman will close the doors and members will be in their seats. The clerk will call the roll.
Representative Byers, Representative Coleman, Representative Croft, Representative Estes, Representative Featherston, Representative Haswood, Representative Helmer, Representative Hoy, Representative Patton, Representative Penn, Representative Potter Partial, Representative Schmidt, Representative Victor's Kozad, Representative Wynn.
Calls to order. Representative Croft votes aye. Representative Hoy votes no. Representative Poskin votes no. Representative Byers votes no. Representative Haswood votes no. Seeing sufficient hands, call the stone order. Representative Penn votes aye. Representative Eric Smith votes aye. Representative Vaughn votes no. Representative Woodard votes no. Representative Wassinger votes aye. Representative Hubert votes aye. Representative Mason votes aye. Representative Sansel votes aye. Representative Featherston votes Representative, you're required to vote. I'll call the House or come to an explanation of why you can abstain. It requires a two-thirds vote of the body. Representative Featherston.
I am voting present on Senate Bill 286 in protest of the process. House Bill 2620 was well-researched in consultation with all of the interested parties. It had bipartisan sponsorship and community support. The bill was heard in committee and passed out with plenty of time to be vetted by the other chamber. Instead, it was held back with no explanation. We had the opportunity to do a good thing here to support hospital workers. I apologize to them and to my constituents for the partisan roller coaster we have all been on.
Body, this is a two-thirds vote. The question is, does Representative Featherston, can she vote present on a final action bill with explanation she stated? Again, it's a two-thirds vote. All in favor and allow her to vote present, say aye. Aye. Opposed, no. No. And those appear to have it. Division has been. We've already got the vote open, so we're going to have to stand. All right. You want to stand and count? Because we can't close the roll. You need two-thirds. All those in favor, stand. With 47 yeses, that fails to meet the two-thirds majority. Representative, how do you vote? Final action, members be in their seats. Body, we're going to have the rule read, so everybody's clear on what the rule is.
Any member who is directly interested in a question may be excused from voting when there is a call of the House. The member who is requesting to be excused from voting shall state the reasons therefor, occupying not more than 5 minutes. The question on excusing such member from voting shall be taken without debate, and a 2/3 majority of members present shall be necessary to excuse such member. If a member refuses to vote when not excused, such refusal shall constitute grounds for reprimand, censure, or expulsion under Article 49 of the Rules of the House.
Representative Featherston, how do you vote? Moving on, Representative Prost.
Thank you, Mr. Speaker. The reason I'm asking to vote president is because outside of the legislature, my primary source of income is a contract I have with a nursing home chain. There was a bill last year that provided immunity, and I voted president on that, but we didn't go to call of the House. So I'm asking the body to allow me to, it feels like a conflict to me. I don't want to vote on it because I feel like I financially benefit from my work with the nursing home. If I'm compelled to do so, I will, but I'm asking that you allow me to vote present.
All in favor and allow Representative Probst to vote present, say aye. Aye. Opposed, no. The ayes appear to have it. Ayes do have it. Representative Probst can vote present. Representative Featherston, last chance to change your mind. All right. Representative Featherston votes aye. Representative Delperding votes aye. The call is raised. Does any member desire to explain his or vote? Representative Carmichael. Yeah.
Thank you, Mr. Speaker. I vote no on the Conference Committee report for House substitute for Senate Bill 286. I have great admiration for our healthcare workers who have done so much during the COVID-19 emergency, and I support the enhanced penalties for battery against a healthcare provider included in this legislation. However, the immunity for healthcare providers in this legislation, while temporary, limited, and only applying in cases where treatment is related to COVID-19, whether the patient is vaccinated or not, requires I vote no on this legislation.
Explanation of vote, Representative Proctor.
Mr. Speaker, I vote no on Senate Bill 286. There are provisions in this bill I like. I like enhanced penalties for violence against healthcare workers. I like the idea of preventing discrimination based on COVID-19 vaccine status. But in this bill, a hospital only forfeits immunity for the patient against which it discriminates, not all of its patients. I don't think this is an adequate deterrent to prevent hospitals from discriminating against patients based on their vaccine status. And more importantly, I will not participate in perpetuating the lie that we are still in a COVID-19 emergency. This lie has been used to destroy lives and livelihoods. It needs to end, and it will only end when we sunset all of the emergency measures, including this legal immunity. For that reason, I vote no on SB 286.
For an explanation, Representative Eric Smith.
I vote in favor of this. This is one of the most difficult votes I've ever taken. I switched my vote. And in my heart, I struggle with that. This is difficult. It means something on both sides. Thank you.
Any further explanation? Representative Sawyer.
Mr. Speaker, I vote no on SB 286. This is an excellent original bill. It's clear our healthcare workers face an inordinate amount of danger in the workplace, and they should be insulated and protected from this sort of behavior. However, there's an obvious poison pill provision here, and I will be voting no. While increased penalties on battery are appropriate, the immunity for healthcare providers regarding COVID-19 treatment is problematic, and I must not support it. I cannot risk rendering all malpractice suits null over the next 10 months. Representatives Clayton, Shue, Ballard, Carlin, Haswood, Stogstall, Ohabisam, Osman, Neighbor, Reese, Byers, Poskin, Myers, Vaughn, Weigel, Reese, Curtis, and Sawyer.
For explanation, Representative Featherston.
Under protest, I have changed my vote from present to yes. I am deeply disappointed that House Bill 2260 became the victim of partisan and special interest politics. However, today I choose to stand with emergency department nurses and doctors that have been attacked and will continue to be attacked at work. Additionally, I encourage any one of you that have been the victim of gross negligence in a medical setting to utilize the legal system to the fullest extent.
Any further explanation? Does any member desire to change his or her vote? Seeing none, with 64 voted in favor and 51 against the passage of Senate Bill 286, the same had received a constitutional majority. The bill is hereby declared passed. The clerk will record the vote. Speaker recognizes Representative Williams for a motion to adopt the agree to disagree on Senate Bill 160.
Thank you, Mr. Speaker. I make a motion to adopt the agree to disagree conference committee report and that a new conference committee be appointed.
Is there discussion? Seeing it. Mr. Representative Owsley.
Would the maker of the motion remind us of what is in Senate Bill 160?
Save Girls Sports.
Thank you. This bill affects other people's children, children who can't help being who they are. They just are. Children down to kindergarten and into college. It leaves no grievance process for those children who it would directly or indirectly impact in a negative manner. Kansas was founded on the principle of freedom. This bill has no place here. Our children deserve better. I would urge you to not support the agree to disagree, and let's keep this bill in conference. Thank you, Mr. Speaker.
Is there any further discussion? Seeing none, Representative, you may close.
Thank you, Mr. Speaker. I close.
You've heard the motion. All those in favor signify by saying aye. Aye. All opposed, no? No. The ayes appear to have it. The ayes do have it. Motion passes. Speaker appoints Representatives Williams, Hoffman, and Owsley as second conferees on the part of the House. Speaker recognizes Representative Williams for a motion to adopt the agree to disagree report on Senate Bill 58.
Thank you, Mr. Speaker. I make a motion that we adopt the agree to disagree conference committee report and that a new conference committee be appointed.
Is there a discussion? Representative Owsley.
Thank you, Mr. Speaker Pro Tem. The Parents' Bill of Rights is in Senate Bill 58. When K-12 heard this bill in committee, there were 6 proponents, not a one of them was a parent. There were dozens of opponents, quite a few of them parents. This creates an administrative nightmare for our school districts. It's an unfunded mandate sent again from this body. It strips local control. I would urge you to not agree to the disagree to Senate Bill 58. Thank you, Mr. Speaker Pro Tem.
Is there further discussion? Seeing none, Representative Williams, you may close.
Thank you, Mr. Speaker. I close.
You've heard the motion. All those in favor signify by saying aye. Aye. Opposed, no. No. The ayes appear to have it. The ayes do have it. The motion passes. Speaker appoints Representatives Williams, Hoffman, and Owsley as second conferees on the part of the House. Speaker recognizes Representative Adam Smith for a motion to adopt the agree to disagree report on House Bill 2106.
Thank you, Mr. Speaker. House Bill 2106 is the food sales tax reduction and elimination bill. And Mr. Speaker, I'd like to move to adopt the agree to disagree conference committee report and that a new conference committee be appointed.
Is there discussion? Representative Gartner.
Thank you, Mr. Chairman. I didn't sign this conference committee report. Didn't go far enough. I think 2 weeks ago I told you, just remember, we're going to get something you're not going to like. And that's what we're going to have later on this afternoon. I'm sure that we'll be discussing. It just doesn't go far enough, fast enough. Thank you, Mr. Chairman.
Is there any further discussion? Seeing none, Representative Smith, you may close.
Thank you, Mr. Speaker. I close and move my motion.
You've heard the motion. All those in favor signify by saying aye. Aye. All opposed, nay. No. The ayes appear to have it. The ayes do have it. The motion passes. Speaker appoints Representatives Adam Smith, Mason, and Gartner, second conferees on the part of the House. Are there announcements? Representative Arnberger Blue.
Thank you, Mr. Speaker. Fed and State Conference Committee is meeting immediately upon adjournment in 144 South to continue on Senate Bill 84.
Representative Adam Smith.
Thank you, Mr. Speaker. House Tax Conference Committee will meet in 218 North at 1 p.m. Thank you, Mr. Speaker.
Representative Landwehr. I wish I could announce an exact time and an exact room for the Health Committee to continue conferencing. We're just trying to juggle the Senate schedule with the House for all bills left in conference. So I would just pay attention, call my office, and we're happy to keep you posted that way. Are there any further announcements? Seeing none, Speaker recognizes Majority Leader Hawkins.
Thank you, Mr. Speaker. I move the House recess until 2:30 p.m.
You've heard the motion. All in favor say aye. All opposed, no. The ayes reluctantly appear to have it. The House is in recess. Messages from the Senate, the clerk will read.
Senate adopts the Conference Committee report to agree to disagree on Senate Bill 58 as appointing Senators Baumgartner, Erickson, and Sykes as second conferees on the part of the Senate. Senate adopts the Conference Committee report to agree to disagree on Senate Bill 160 as appointing Senators Baumgartner, Erickson, and Sykes as second conferees on the part of the Senate. The Senate adopts the Conference Committee report to agree to disagree on substitute for House Bill 2466 as appointing Senators Baumgartner, Erickson, and Sykes as second conferees on the part of the Senate.
Changes of conferees. Representative Adam Smith, Mason, and Gartner are appointed to replace Representative Stephen Johnson, Croft, and Neighbor as conferees on House Bill 2136. Announcements. Representative Woodard on an announcement.
Thank you, Mr. Speaker. Democrats will have agenda immediately upon recess in 152 South. Thank you, Mr. Speaker.
Are there any further announcements? Seeing none, Majority Leader Hawkins.
Thank you, Mr. Speaker. Republicans will calendar in the old Supreme Court room upon recess. Mr. Speaker, I move the House recess until 3 p.m.
You've heard the motion. All in favor say aye. All opposed, nay. The ayes have it. The House is in recess. The House will be in order. Messages from the Senate, the clerk will read.
The Senate announced the appointment of Senator Peterson to replace Senator Hildebrand as a conferee on Senate Bill 84. Senate announced the appointment of Senators Tyson, Peck, and Holland to replace Senators Olson, Hildebrand, and Faust Godot as conferees on House Bill 2136. Senate concurs in House Amendments Senate Bill 150, requests return of the bill. Senate adopts Conference Committee report on House Substitute for Senate Bill 91, Senate Bill 408, House Bill 2109, House Bill 2299, Senate Sub for House Bill 2361, House Bill 2377, and House Bill 2508.
Representative Kelly for an announcement.
Thank you, Mr. Speaker Pro Tem. The Financial Institutions and Rural Development Committee and the Senate Fed State Committee will conference right now. It'll be at 4 o'clock in 144 South. So 144 South, 4 o'clock on bills in conference, which are housing bills.
Speaker recognizes Representative Waymaster for motion to adopt the Conference Committee report on Senate Bill 267.
Thank you, Mr. Speaker. I move to adopt the Conference Committee report on the House substitute for Senate Bill 267, which is the budget bill. So I'll just kind of go through some of the highlights of what occurred during Conference Committee between the House and the Senate. I prefaced this in calendar when we were talking about it with our caucus. I think the House did very, very well in Conference Committee. So some of the items that we addressed with the Senate was the docking state office building and the new KDHE lab. We're appropriating $92.5 million with the condition with the Department of Administration that they try to utilize as much in federal funding as they possibly can. There's been a conversation with the Secretary that they may be able to use more federal dollars. We fully fund the Kansas Department of Health and Environment Health with the $360,000 for the remainder of 2022 for the breast and cervical cancer early detection program. We have $150,000 going to each the Department of Ag for the dam safety program and $150,000 to the Kansas Water Office for the water injection dredging at Tuttle Creek Lake. We also agreed, and also to have this discussed at Omnibus, $80 million, paying off some of the bonds that we have in regards to some reservoirs across the state, but we're going to have that discussion later on this coming month. But we do have that $80 million that is going to be extracted from the state general fund. In regards to the community colleges across the state of Kansas, we actually had our funding model that the Senate adopted in regards to the funding of the community colleges, but we are going to have a interim working group that is going to be discussing the funding formula for the community college that has been in statute for many years, but not necessarily followed. In regards to NIAIR, I know we've been talking about that quite a bit. We did take the Senate position on that. Ours was $35 million to be taken out in fiscal year 2023. The Senate's position was actually $7 million over 5 years. The only caveat to that, and we expressed this with the Senate, is that that $7 million is not going to be baked into the state general fund allocation for Wichita State University after the 5-year period has expired. DCF, we actually came to an agreement. We were at 5 in our original bill. The Senate was at 10. So we came to a mutual agreement of $7.5 million for the workforce recruitment and retention incentives for child placing agencies. $1.4 million all funds for the child health insurance program. We have all of our money that we had in our original bill for 267 for the Kansas Department of Aging and Disability Services, with the exception of one item that was very important to the Senate. And so that's why we were able to keep all of the items in the position of the House. And that was in regards to the Senate's position on the HCBS and IDD waiver. We were at 14%. They were originally at 30%. And the Senate didn't want to move off of 25%. So we were able to keep our items in regards to KDADs so the Senate could have their position of 25% for the HCBS and IDD waiver. We did go ahead and take the Senate position as well in regards to new aircraft with the Highway Patrol. And so that is going to be purchasing a new helicopter, a new Caravan that I believe is going to be housed in Hayes. Both of those aircraft are going to have what's called flares, the forward-looking infrared devices on those pieces of aircraft. And then we also have in there, which was a Senate position, a purchase of a new executive aircraft and trading in the King Air. The Senate accepted our pay plan that we had in our budget. If you recall last week when I was here and I was describing the pay plan for the state employees, if you are currently in a pay progression plan, you would not be subject to the 5% increase across the board, which is what the Senate had. They had just a 5% increase for all employees. We basically said if you're in any type of pay progression plan or you had a market increase recently, you would not be subject to the 5%. Inadvertently, we had left out the judicial branch. And so one modification that was made was that the judicial employees, non-judge and judge, would be included with the 5% pay increase. We also do have pay parity with the Kansas Highway Patrol, and this was brought up in our calendar, so I just wanted to make sure that also includes the Capitol Police. So the law enforcement that we have here in this building will have the pay parity. And then we also have the GBA that was accepted by the Senate, not by the House, which was about $3.6 million for salary adjustments for the Kansas Bureau of Investigation. The other items that you'll look at, and I can kind of explain, I'm not going to go through each one, but when the governor had submitted her budget back in January, there was an allocation for what was called the University Challenge Grants. And these were grants that were going to be administered to the Department of Commerce for our 6 regent schools, and they were going to be used for economic development purposes. That was $195 million that was allocated in the budget. We had pared that down a little bit, where we funded about $38 million for community colleges that had made submissions for the ARPA funds, the American Rescue Plan Act money, with the advisory panels for the SPARK committee. In consultation with the Senate and other economic development programs or submissions that were made for the federal money that is sitting with the advisory panel, we decided not to do the University Challenge Grants and instead use this one-time money that we have from the federal government in regards to the ARPA funds and fund the community colleges that we had from the University Challenge Grants, economic development policies, rural housing, moderate income housing, have all of that funded with the ARPA funds that is with the SPARK committee. So I just kind of wanted to briefly touch on that. Also in this bill, it does have the bill that we debated on the House floor last week, which is the claims against the state. So all of that is in here. And with all the other provisions in the budget, we wanted to be respective of saving money. I think I said this last week when I was up here. Our initiative was to pay down debt and put money away, because we know that sometime, somewhere, someday, a recession is going to be looming on us. And so we have $500 million that is going into the Budget Stabilization Fund, and we are also going to be discussing an extra $100 million possibly going into the Budget Stabilization Fund at Omnibus. So with all those items and the House position pretty much maintained, I feel very confident about how well we did in conference. We are ending the state ending balance at $895 million. When I was here last week, we had an ending balance of $1.5 billion. The Senate had one that was a little over $300 million. When we left conference, we were a little over $1.1 billion. But in the 895 ending balance that you see in your sheets, that is reflecting Apex, the Capers bill that we passed yesterday, the various tax agreements that have come from the tax committee. So it is factoring all of those. Some of those have not yet passed those conference committee reports, but it is reflective in the profile so we could show exactly where we are ending. So we are ending, if all those were to pass, we will have an ending balance of $895 million, a 9.9% ending balance, and that still does not account for the amount of overage that we are from our November consensus revenue estimate numbers of $316 million as of today. That'll be reflective when we have the new CRE numbers in April. So with that, Mr. Speaker, I would stand for questions.
Is there discussion? Representative Wolfmore.
Thank you very much, Mr. Chair. I do support this budget, and I first want to start with thanking my conference committee team, the chair and the vice chair. You know, they were just a pleasure to work with. The chair and I have our tiffs once in a while, but I consider him a very good friend, and I think we did very good work. And for the most part, it was great to work with the Senate team. I mean, obviously, we were the superior team, but it was still a pleasure to work with them. So I think in this budget, we put real money behind some things that we definitely needed to put money behind, and that, most importantly, at the top of my list was the 5% raise for the employees, our most valuable asset. So I'm really thrilled that we got to do that this year. We raised the profile of water and did a better job of funding water this year. And so it's time to do that, and so I'm so glad we did that. Higher ed, we did some really good things. I'm not going to go through it all. The chairman did a great job of covering it, and I covered it in my caucus, but we did some great things with higher ed and the community colleges, and using some of that, the power of those federal dollars to have some lasting impact. And I think that's what we all hope those federal dollars would do, instead of just frittering out everywhere. I think we've done a really good job of harnessing some of it. I have to give a shout out to the Social Services Budget Committee that reported in. You know, they did some much needed good work and brought us some really good things. The chairman mentioned the IDD funding, which was so important. So thank you for all your good work and all the things you brought forward to us. Housing was another great thing. You know, I'm from the urban area, but I'm particularly proud of the money we put in rural housing. If we don't put money in rural housing, we are not going to be able to attract the businesses there we need. So I'm particularly thrilled we did that. All in all, I think we passed a very good budget. I'm very proud to stand here and support it, and I hope you will too. Thank you so very much.
Representative Carlin.
Thank you, Mr. Chair. Mr. Chairman, would you stand for a question or two? Hi. I have been really, really pleased with the budget all year, and the process has been really good. But I do have a couple questions. The governor's budget had done some excuse me, cleanup of some messes that had been laying around, like the school payment and all that, and I don't know how those turned out, you know, to make up that payment that was on June 30th, July 1st deal. Did we take care of that?
That is actually being discussed and is being addressed in the education budget.
Okay. And do you want to mention, just for the body, what we've done with KDOT and CAPERS, just briefly?
Well, with KDOT, if I think I know where you're going with this question.
I'm not unaware, but I wanted to kind of share.
This is the first time, actually the first time since I've been in the legislature, that we are not doing an extraordinary transfer from the Kansas Department of Transportation Highway Fund into the State General Fund. I don't like using this term, but many call it the Bank of KDOT, and we're not doing that in this budget. Kansas Department of Transportation is fully funded. In regards to CAPERS, obviously that was a discussion that we had yesterday with Senate Bill 421, which is our initial position had been $1 billion with the layering payment included in that, but in negotiations with the Senate, it was a little bit higher than that. So we're doing, look at the chairman, but we're doing the layering payment and $1 billion when it's all said and done. But that'll be a cost savings to the state in later years for an employer contribution.
Thank you. And paying off the debt was a high priority for the governor. And was there any other debt that was paid off in this negotiation other than the CAPERS debt and the
The only one that I would probably say is most likely going to be paid off, and that's going to be in regards to the water reservoirs that we have bonds on. And there's debt paid off there as well.
Thank you, and I appreciate all the good work that you've done all year. We had a good start. We had some money, which is the first time in my 20 sessions that we've really had enough money to do what we needed to do. And I believe you don't need to answer because I do know the answer, but we did pull the $4 billion MCO bill extension out of this budget, which is why I voted against it the other day. $4 billion non-legal procurement according to our processes. And I don't know how many of you may know this, but the reason the docking building is an issue around here is because there was a sale of land that belonged to the state, and it was sold without going through the proper processes, without us voting to do that. So we had to turn around and take care of a settlement then that cost us $2.4 million just to get out of the deal. But, you know, it was a mess. We have procedures, and I want those procedures to be followed, and I will not support that $4 billion wherever it shows up. But I do support this budget. I'm really pleased with it. It's been a real relief to me to see all the things we've been able to do for IDD, mental health, and all the people of Kansas. And thank you, Mr. Chairman, for your hard work and our ranking D. Thank you.
Is there any further discussion? Seeing none, Representative Waymaster, you may close.
All right. Thank you, Mr. Speaker. I close.
Body, we have a couple of members out on a conference committee. We're going to go ahead and start into final action, but we'll wait for them to return. So this will constitute final action on Senate Bill 267. The clerk will open the roll, and you may record your vote. Has every member had an opportunity to record their vote? Clerk will close the roll. Does any member desire to explain his or her vote? Does any member desire to change his or her vote? Seeing none, 104 having voted in favor and 12 against the passage of Senate Bill 267, the same having received a constitutional majority, the bill is hereby declared passed. Clerk will record the vote. Speaker recognizes Representative Blex for a motion to concur in conference on House Bill 2279.
Thank you, Mr. Speaker Pro Tem. It's a great honor for me to be up here on this particular bill. I've had a lot of passion with it. This is a Senate substitute for House Bill 2279. And I want to thank leadership for allowing me to bring this discussion on the floor. And I know it means a lot. I'm going to make a motion to concur with the Senate, the Conference Committee. And, you know, I really respect the process up here. I think sometimes we hear words that it's not working, but again, I want to thank leadership for being flexible enough to allow me to do this. And some people are wondering why I'm up here instead of the chair and the vice chair. And with all due respect to the Madam Chair, I want her to know that I respect and value her passion and knowledge on health issues. I've sat on that committee for 6 years, and she's been chair for, I believe, 4 years. And especially in the mental area of mental health. I'm just in awe on that. But and normally I follow her lead on most of the committee votes. But on this particular issue, on this Senate sub for House Bill 2279, we're quite a ways apart. And yet I appreciate that, and I get that. And I know she doesn't care for the bill as written, and we've tried to work out some compromises on this particular bill. And I know somebody told me in the hall, I heard that, hey, have you heard the representative the chair is supporting? And then they got me on, I forgot this is April Fool's Day, so I didn't get to do that. So I don't know, the day ain't over with yet, so we may see. But anyhow, I've sat on that committee, and we had, in 2019, we had an intense roundtable, and I applaud the chair for doing that. It was 2 hours we brought in physicians and APRNs and sat down about 3 to 4 on each side and had a really good discussion, run well over into the committee time limit and heard a lot. I actually carried that bill out on 2066 in 2019. It was gutted, Medicaid expansion put into it. So that's kind of where we are. We had COVID, and right now, what happened now is the Senate Public Health and Welfare Committee actually heard a bill, and it's been worked in there. And you may even hear this is going to be a bad bill, and we might even get sued. And I'm not an attorney, but I have talked to the revisers and some national attorneys for the association, and they're good with it. And I just want transparency. And so basically, when the Senate heard it, it was actually Senate Bill 454, and there was testimony. The National Council of State Boards of Nursing provided proponent testimony, and written only was provided by Kansas Chamber, Kansas Justice Institute, Kansas Board of Nursing, and Kansas State Nursing Association. And representative opponents were the Kansas Academy of Family Physicians, Kansas Academy of PAs, Kansas Chapter of the Academy of Pediatrics, Kansas Medical Society, and the Kansas Association of Osteopathic Methods. So the Senate actually amended the bill and actually went into that with requiring the board, which is the Board of Nursing in this case, to consider the scope and limitation of the advanced practice nursing in accordance with state laws when defining the role of APRNs. And they also put in there, they prohibited an APRN from prescribing any drug that was intended to cause an abortion. So the Senate committee amended that and inserted that contents into 454 into the House Bill 2279 and become the Senate substitute for
that bill. And it actually went, and we haven't heard it in the committee this year, but the Senate had full floor debate on it. And I watched it. It was fairly lengthy, a lot of good, lively debate, and it passed out of the Senate on a bipartisan vote, 30-7. So really a good, I think that shows the support for it. And what this bill will actually do, I guess I'll get around to that, which I should have done that first, but it will actually allow a APRN to prescribe drugs without a written protocol as authorized by a physician. It will also require that APRN to have a controlled substance, a national certification for the Uniform Controlled Substance Acts. In other words, they need a DEA number to deal with any controlled substance. They'd also require an APRN to have malpractice insurance. So that's kind of the intent of it. This bill does not change the scope of the practice. We've seen COVID in this last couple of years. APRNs has been the go-to person. I go to the VA, guess who I get to go to? APRN. They're seemingly they're not doctors, nor will they ever be a doctor, and certainly they're a point in our healthcare system that we need access, and we need somebody to go to, because Kansas has 100, and out of the 105 counties, there's a healthcare crisis in almost 102 counties. So we do need some access there, and I think this bill will make it more accessible. But the thing we need to remember, that we're not changing the scope of the practice, and the collaborating agreement, which has been a big issue, and even in those previous bills that we heard, 2066, they were a little different. They had some like 4,000 hours in it for them before they could get this. But the bottom line of it is the theme and the base thing of all those bills that we've looked at in the previous 4 or 5 years has been one thing. We want to eliminate the collaborative practice agreement and allow the APRNs to do a full practice authority. You've seen 24 states has already done this, so I think that's a good indication of what's going on. And certainly we're seeing healthcare issues, and I just strongly support this. I've been pretty passionate. Like I say, this has been 6 years I've been working on this thing. So with that, I will stand for any questions that you might have.
Is there discussion? Representative Epley.
Thank you, Mr. Chair. If I could just indulge your attention for just a minute, I just have a few comments I want to make about this bill and why I'm very opposed to it. I guess it's kind of like Happy April Fool's Day for, at least for the physicians in the state. I guess it's a good day to have this discussion, so we'll have it. This is an issue that I, as a physician in the state of Kansas, have worked on in good faith for at least 8 years. I've been on round tables, I've been on square tables, I've been, in committees, I've been on ad hoc committees. I've tried really hard to move this forward. I ardently, fervently believe in nursing. I'm married to a nurse. 2 of my 3 children are RNs. I believe in nursing. I'm all about nursing, all about them being part of the healthcare team. But I assure you, in all these endeavors of mine, we've worked hard towards compromise, and there just hasn't been any compromise on this issue from the other side. Leadership will tell you we've sat in on several discussions with this group, and it has to be their way or the highway. We have given up a lot of concepts, and one concept in particular that's ancient history, in my opinion, is the collaborative practice agreement, the CPAs. That's fine. I'm all about APRNs having independent practice. I think it's time for them to have independent practice, but it has to be done the right way. I grew up in southeast Kansas, and my father told me there's 2 ways to really do things, the right way and the wrong way, and you do it the wrong way, you're going to end up doing it the right way anyway. So you're going to come back and have to clean this bill up, because this bill is not ready for prime time. It's woefully inadequate for what our needs are for the state of Kansas. We want effective mid-level providers to be there as APRNs, but it has to be done the right way, and this bill, as you're going to hear, is not the right way. As example, I really feel like bad politics follows bad policy going forward with this bill. Like I said, this was House Bill 2279 started out as a PT compact bill. It then was gut and goad, and then it became Senate Bill 454. And they're going to say it had an adequate hearing, and I'm going to say, no, it didn't. You know, notice was sent out one day in advance. The opponents were not able to give adequate testimony. There was less than an hour of testimony given, and most of it was for those that were in support of it. Item 3, national certification is not the same as licensure. And you're going to hear, well, we're getting certification. We're getting certification on this, and that's adequate for our needs. There's much more to that. You have to be vetted through a board of healing arts or through a licensing board. Now, they're going to say the Board of Nursing is adequate for this, and I'm going to tell you, I think the Board of Nursing does not have near the experience or the depth of knowledge on the regulations that's related to the practice of health care in the state of Kansas, whether it's the nursing process or the process of practicing medicine. So I urge you to bear that in mind going forward, that national licensure is not the same as being licensed, and that national certification is not the same as licensure. Scope of practice is not addressed anywhere in this bill. What is scope of practice? Scope of practice is where it says what you do, what your limitations are. You have to put that in statute. That's in statute for all other healthcare providers. It isn't for physicians because we're at the top of the heap and we're defined as practicing medicine and surgery in the state. But all other healthcare providers have a defined scope of practice in statute. This does not have a defined scope of practice in statute. You're going to have to come back and do that if you pass this today anyway. I mean, that's what you'll end up doing at some point. The Board of Healing Arts does cover, I mean, that's how we license people in the state of Kansas that practice medicine. The Board of Healing Arts licenses 16 different providers of health care in the state of Kansas, including PTs, OTs, podiatrists, chiropractors, even naturopaths and physician's assistants. The PAs are a prime example. They have an advisory board that advises the Board of Healing Arts, and then they get additional privileges or regulations as needed. It works out very well. It's a free-flowing situation. Next issue that I have angst about this bill for is malpractice. Now, yes, the bill says they're going to have malpractice, but it's not in statute what their level is going to be. Even for physicians, it's in statute what level we have to have. We have to have 1 million, 3 million. We have to have 1 million per event, 3 million aggregate. Okay? That's not defined in this bill. Again, you'll be back defining that. Do they engage with the Healthcare Stabilization Fund? We don't know. It's not in the bill. Folks, there's nothing in here about the Healthcare Stabilization Fund. How are we supposed to know that they've got that umbrella coverage that they need to practice safely in the state of Kansas so that my patients, their patients, have the right of recovery if they're injured or if there's a problem? This is really a serious flaw in this bill. It's just too lean, it's too thin. There's not enough statute there about malpractice. The experience difference is extreme here, and others will talk about that. You know, I probably went to school longer than most MDs because it took longer, but, you know, I had 16,000 hours, I think, of total training, and for them to have 700, 900 hours and then think they're going to have full practice authority, I think that's a problem, and they're going to say, well, it's just the nursing practice. It's just the nursing methodology, and I'm going to say, well, you know, if it looks like a dog, barks like a dog, wags its tail like a dog, it's a dog. They're going to be practicing medicine, so we have to have statutes that allow them to practice safely in the state of Kansas. You have to make allowances for that. And again, the PA issue, I brought that up. What are we going to do with PAs? That'll be a bill next year, because then we'll have to provide independent practice for physician assistants, and good luck trying to figure that one out. I mean, that's just going to add another layer of issues unless we fix this bill and send it back and make us come up with better language so that we can pass a more effective bill. Finally, in conclusion, and I know I've been here a while and I appreciate your attention because I try not to come here very often, but now that I'm here, I'm going to say that I'm here on behalf of almost 2,000 family physicians in the state of Kansas. I have treasured my relationship with them. I've been a past president of the Kansas Academy of Family Physicians. Most of you know some family physicians in your district. You know how they feel. They agree with me on all these issues that I've outlined to you, and I would ask that you honor this relationship with family physicians in the Kansas and vote to non-concur with this and send this back to committee so we can work on these issues that need to get ironed out. With that, I will step down and be happy for any questions on my comments. Thank you.
Representative Clifford.
Thank you, Mr. Speaker. Colleagues, I'd like to proceed my remarks by saying that nurse practitioners are exceptional colleagues, but we're all victims of our training, as I like to say. We all have blind spots, and certainly, as been pointed out by the previous speaker, nurse practitioners, other advanced practitioners have quite a few more than we physicians. I want to talk about a study that's at your desk provided by the previous speaker, and then I'll mention 3 patients briefly. That study is of a primary care clinic, not just any clinic, one with 120 practitioners and 300 physicians. That clinic was ranked #1 by CMS in the country in 2016. And they went about a study over 2 years, 2017 and 2019, of CMS quality data to look at their results. What they found was physicians were better on 9 of 10 quality measures. They also found that physicians were better on 6 patient satisfaction measures. More importantly, for the operation of their clinic, nurse practitioners costs on average, or created costs on average of $43 more per enrolled patient per month. And this clinic took care of 33,000 patients. That was a $10 million number. If they factored in patient complexity, it was $120 per patient per month. So there certainly was no cost savings. And why was this occurring when they looked at the data? More tests were ordered by nurse practitioners, there were more specialist referrals, and there was greater utilization of emergency departments. So what did this clinic do last year? They changed their practice to eliminate independent practice by practitioners and required physician visits annually. I want to tell you about 3 patients. I could tell you about many more. I was asked by an advanced practitioner to see a patient she had been following for 3 weeks for a red eye. And as I walked over to that clinic, I was from here to my chairman of the Social Services Budget Committee, from the patient, and I turned to her and I said, "Can the patient hear a noise in their ear?" And she went ahead of me and asked that and turned around and said, "Yeah, they hear a swoosh, swoosh, swoosh." And I asked the patient one question, "Have you had a recent fall?" And the gentleman said, "Yes, I was at a convention in St. Louis and I fell and hit my head. And since then I've had this swooshing noise and my eye got red." Well, that's a carotid cavernous sinus fistula. And anyone who's had weeks of neurosurgery would know that instantly, that that's the reason for unilateral non-healing red eye. And that patient went to KU for a coil put into their brain to stop that flow. Second patient was a smoker with laryngitis. If you had had general surgery, ear, nose, and throat, pulmonary medicine, you instantly think that's an apical tumor in the lung, not laryngitis for which that patient was being followed. And finally, more recently, I was referred a young woman who had kind of strange-looking optic nerves, and the presumption was glaucoma. Well, that patient has since had 2 surgeries in Denver for what actually was a brain tumor. So I bring these to you because this is my world, and this is the world of collaboration which we need. And this legislation, which would allow independent practice, and more importantly, the Board of Nursing to describe what that practice would be, is something which I'm against for the sake of my patients. Thank you, Mr. Speaker.
Representative Landwehr. Representative Proctor. Reminder members, please extinguish your lights after you're done speaking.
Thank you, Mr. Speaker. I rise in support of the CCR. We've got a crisis of access to health care in North Leavenworth. We lost our hospital, can't deliver a baby in my town anymore. You know, a lot of stuff folks have to go out of town for, but a lot of folks can't go out of town. And so these APRNs, these practices, fill a huge access gap in our town that otherwise would go unfilled. You know, in an ideal world, we would have a doctor's clinic on every corner, and that wouldn't be, it wouldn't be required, but that's just not the case in Leavenworth. We got a 20% poverty rate, and the doctors have followed the money out of town. And so if, in my town, if you want access to health care and you're not a veteran who can access the hospital on Fort Leavenworth or the VA, an APRN's your only option. You know, we get accused on my side of the aisle, we get accused by the other side of the aisle for being a no on Medicaid expansion without offering any options. Well, here's an option to provide people with low-cost medical care. And, you know, I say don't look a gift horse in the mouth, frankly. We have the ability to make this more affordable and make more of them. We should do that. Thank you, Mr. Speaker.
Representative Prahl.
Thank you, Mr. Speaker. I won't belabor the point a lot. It's been brought up before, but I do want to mention it. There is no defined level of malpractice coverage in this bill. I have the privilege of sitting on the Healthcare Stabilization Fund, which has been mentioned that it's an umbrella for malpractice. This is not mentioned at all in this bill. I have concerns, you know, where is the malpractice protection for Kansans? I see the claims that are filed. Many claims that are filed are in excess of $1 million. And there's no level that's shown any place. So I just want to bring these concerns to the body, and I thank you for your attention. Thank you.
Representative Bergquist.
Thank you, Mr. Speaker. It's been made very clear, and it's very well respected in this body, that there are medical doctors here, and there are nurses here. There are teachers here. There are scientists here. We have great expertise and ones that have already given testimony today. I have a great respect for doctors, and I have always had a great respect for doctors through my life, because I grew up in a home where there was a registered nurse for 45 years. She had a great respect for medical doctors, and she answered to them every day. In her practice as a floor nurse and as a specialty nurse, she dealt with doctors all the time. She dealt with them on the terms of the scope of her practice. In the 1940s, 50s, 60s, 70s, it was a different scope of practice than it is today. But those specialties have grown, and advanced practice registered nurses are able to, within the scope of a specific practice, they can license to do not what medical doctors do, but what nurses do. My respect over the last 5 years of being in Health Committee working with two chairs, including the present chair, who I have a great respect for, and for the previous chair. An effort has been made to bring this issue to light, and a lot of times it's been hard to get hearing. In 2019, it came to that ending with the change of the bill. That's nothing to go back and stress about. The stress is that during that time, we had hearings, we had roundtables, which I took part in, and that roundtable wasn't just 3 or 4 of both sides. It was a room full of the Supreme Court room, the old Supreme Court room, of specialists on both sides and opinions on both sides. And that dialogue was very well orchestrated between both sides to be able to hear the issues. The other thing that I really appreciate is the fact that during those 5 sessions that I've been in committee, I've also been able to get to know a lot of APRNs and CRNAs, a lot of specialty nurses who go above and beyond to be able to provide. For all of you that live in rural areas that are away from metropolitan areas that don't have quite the amount of specialty medical services that others do, can probably relate to the fact that there are times when you're just glad to have somebody to make an initial look at your issue. No APRN is going to say that they're the last word on a serious condition. But if you have no one but an APRN to go to on a day with your child and you have a question, you don't have anybody to refer you or to send you or encourage you to go to a medical doctor for a likely condition. We don't keep doctors in our homes to be able to, or even a medical book couldn't give us enough guidance in a hurry to tell us that we probably need to take the next step. These collaborative agreements that have taken place over a number of years between nurses and doctors have been a connection to have there's a decent respect between the two practices to recognize that they're both two things. If we think that, and the reason I say that it's been good to know the APRNs over this past number of years is that I've seen a track record of their intent to provide the services of a nurse and not of a medical doctor. And I truly encourage you to vote for this measure. This is not to disrespect anybody else's opinion who has great knowledge more than me on medicine. But I do understand nursing, and I do understand that those practices that take place in the VA hospital over a number of years, and those that happen in rural communities today with very little direct supervision of a medical doctor, are providing services that we've been looking for in this body in discussions and in ways to find health care answers. That doesn't mean replacement answers for medical, but it does mean some relief to be able to give some hope for rural communities and indigent communities to be able to get help. I appreciate your support for 2279, and I appreciate your time. Thank you, Mr. Speaker.
Representative Delperdang.
Thank you, Mr. Chair. We've been asked to concur on 2279 for the APRNs, but it is a bill we really haven't heard in the House yet, but we've been told it'll help fix the doc shortage. We did hear 2266 a couple years ago, I believe it was 2019. That got gutted at the time, so it didn't get too far here. But I did a little searching on what we do have for med schools here. We've got KU Med, and on average, they bring in about 200 students each year to their med program. But what I found out is, of those 200, approximately 150 are from out of state, out of country. Only about 50 of them come from Kansas. So I asked you, why is there a doc shortage in Kansas? We're only bringing in about 50 of our own students each year. Over the past couple of years, we've had some changes to the medical communities. Wichita, which is where I'm from, now has a DO school. We've heard that the osteopathic schools oppose this bill. I've talked many times with Dr. Tiffany Masson down there, who's the president of the college. She's received mass opposition from KU Med. They refer to her operation as the Devil's School. Wichita is finally getting the med school, though, of significance. I don't want to mess that up. Will this be a nail in the coffin of the Kansas School of Health Sciences? I don't know. But the question is, what is the root problem of the doc shortages in Kansas? Are APRNs the real answer or not? Can these two actually work together? As I said before, I don't want to hurt what Wichita's already got. You've heard there's issues with the bill. The question is, should we work these out before it goes any further? So I'm still really struggling where to go on this. At this point, the last time it came up, I was a yes vote. I'm questioning if I'm a no vote until some of the issues get worked out. But thank you.
Representative Susan Ruiz.
I stand here in support of this bill, of House Bill 2279. You know, as a social worker, I see this as access to care. I've heard from many nurse practitioners, and because some of these nurse practitioners, some are familiar with me as a social worker, and they have felt like they could be pretty honest with me about the fact that we do have a shortage of primary care physicians. What the study has to say, and this actually came out of the Kansas Chamber, they said 85 out of the 105 counties in Kansas have a shortage of primary care physicians. That's serious. And there's a lot of differences between, and I want to bring out some of the stuff about the APRNs that I think it's important for everyone to know, and at least to be able to explain why I think that they should be granted this full practice authority. My primary experience has been in mental health, and primarily with the community mental health centers here in Kansas. And so there's 26 community mental health centers in Kansas. And some of these community mental health centers have a lot of counties that they provide services for. And it's in some of these areas where they have the biggest shortage of psychiatrists. Psychiatry is not a field in medicine that we have a lot of people wanting to become psychiatrists. But there are nurse practitioners who are willing and are attracted to being able to work with people who have a mental illness, and in particular with folks who have a severe mental illness. I've helped construct these collaborative agreements before when I worked at a community mental health center, so that a psychiatrist could have this collaborative agreement with the nurse practitioners. But the reality is a lot of our psychiatry that is being provided in the state is being done by nurse practitioners and not by psychiatrists. These centers struggle a lot to have psychiatrists. The issue about the malpractice insurance, that the level of malpractice insurance is usually set by the insurer based on risk. So, for instance, I do work at a hospital. the hospital has malpractice insurance that covers me. If I wanted extra insurance, I can get that. It's the same thing with the nurse practitioner. If you're working in a hospital, you're working at a clinic, you are covered by that malpractice insurance, and you can get additional malpractice insurance. And so it does depend on the risk. The risk is, are you going to be working in a hospital, you're going to be working in a clinic, or are you going to be opening up maybe your own practice? Then your level of risk is going to be higher. You're going to be required to have more malpractice insurance for that. We know that there are 24 states that already grant full practice authority for nurse practitioners, and the VA system is one of those. Military bases also allow for full practice authority. And also, APRNs are more likely to practice in underserved areas and care for large numbers of minority patients, Medicaid beneficiaries, and uninsured patients. And that is that piece that for me is important, because that means more access to care for people that live in our rural and frontier areas of the state. I've received letters from nurse practitioners who struggle to have those collaborative agreements with physicians because there aren't physicians around for them to do that with. And we have people that are without access to care, to health care, basic health care. Also, when you have more nurses practicing, people are more likely to go in for their routine checkups. They tend to improve their quality of care and decreases emergency room use. And we should all be concerned about emergency room use, because we as taxpayers have to pay for that for people who don't have insurance. And it's for all these reasons that I think that we really need to consider this, granting the APRNs this full practice authority. This is not about whether you're a physician or a nurse. Think about the people that need the access to this care. There are places in Kansas that don't have a physician in their town unless they're connected to a hospital. If you had an APRN who would be able to practice there, they could. Then you would be able to have people in these towns to be able to not have to travel so far to go and get just even basic health care. Just having just going in for a checkup. You get all your systems checked out. A lot of us don't like to do it, but it's necessary, and we know it is. But there are people who want that and can get to that because we don't have enough people that can provide that service. APRNs would broaden our access to service. I ask you to consider voting yes to HB 2279.
Representative Landwehr. Representative Howell.
Thank you all, and thank you, Speaker, for allowing me to comment. I'm very excited to have the opportunity to vote on this bill today. This is a topic that I have personally watched and learned about for a number of years and just had a personal interest in. And so it's exciting that I get this unusual opportunity in my case that I get to push a button today. So I'm just personally grateful for that. To speak directly on this bill, I just wanted to give you all just four brief examples in my family's life of times that medical healthcare providers have not provided the right diagnosis or missed items that they should have caught. One family doctor ignored a first-time mother in my family that was concerned about her baby's eyes. And about 8 months later, her infant, my nephew, was diagnosed with bilateral blastoma, which is cancer in both of his eyes. He ended up losing one eye and is legally blind in the other. If the family doctor had caught it earlier, he probably would have both eyes and maybe have enough vision to be able to truly function independently. Second, multiple ER doctors and an ENT gave me poor medical advice and taught me to incorrectly treat my idiopathic anaphylaxis over the years, which could have resulted in my death, because even though most of you probably sitting here in this room today do not know what idiopathic anaphylaxis is, I think you do know what anaphylaxis is. And if you treat that wrongly, you stop breathing and you will die. And third, I had to personally insist to an ER doctor to run a test on my son, who ended up having an orbital fracture, which could have severed his optical nerve, resulting in his permanent blindness. Fourth, most recently, a relative of mine saw 6 different doctors, mostly specialists, and eventually had to insist on a biopsy, where she was found to have stage 4 cancer. All 6 of those doctors missed completely. When that biopsy was finally done, and which, by the way, another APRN family member had been insisting and recommending on that biopsy all along, it was found that she had stage 4 cancer, and it had been missed for months. All of those are all Sedgwick County local experiences in my family in the last 20 years. So I say all that not to throw physicians under the bus. They are wonderful, but to say that obviously all types of medical providers are capable of mistakes and missing diagnosis. So that is not a reason to vote yes or no on this bill today. This bill today is about giving patients and Kansans options for affordable health care. This cannot be underestimated in its importance. And this is a valuable tool in doing that. And I just want to urge you in joining me in voting yes on this bill today. Thank you.
Representative Landwehr.
Thank you. Some of you have heard my point several times, and one of the things I talked about the last time was statutes that were not necessarily here. Now my screen has moved. I'm going to have to find it. There we go. And I referred to you to 651113, and I'm just going to read Section D. Practice of nursing. The practice of professional nursing is performed by a registered professional nurse for compensation of gratuitously, except as permitted by KSA 651124. And amendments thereto means the process in which substantial specialized knowledge derived from the biological, physical, and behavioral sciences is applied to the care, diagnosis, treatment, counsel, and health teaching of persons who are experiencing changes in the normal health process or who require assistance in the maintenance of health or the prevention or management of illness, injury, or infirmity. Administration, supervision, or teaching of the processes defined in this section, and the execution of the medical regime as prescribed by a person's licensed to practice medicine and surgery. or a person licensed to practice dentistry. Practice of medicine and surgery is the definition of a physician in our statutes. In the Nurse Practice Act, not Board of Healing Arts, Nurse Practice Act, medicine and surgery is referred to 10 times. We asked for that language to be put into this bill, and we were told no. No reason why, just no. They said they didn't want the word physician tied to nursing, but yet it is 10 times in the Nurses Act. Surgery is tied into the Nurse Practice Act 13 times. I know that you've heard that according to our revisers, that this bill is okay. One of the comments that was made in the conference committee the other day was, the Kansas Nurse Practice Act defines diagnosis in the content of nursing practice and expressly provides that a nursing diagnosis is distinct from a medical diagnosis. And yet you've heard folks up here talk today about what would actually be described as medical diagnosis. Neither statute nor rules and regulations enumerates a list of acts that are within or outside the APRN scope of practice. (651113) is referred to in this example. And I believe it was 651124 is another one that's mentioned in examples, and none of these are in this bill. And the phrase I just read to you is what was said by the reviser of the Health Committee during conference. So because these statutes have been left out of this bill, and if you look at the difference between the bill from 2019 and now, there was going to be 4,000 hours that someone would have to have versus their 700. That 4,000 is gone now. They said they wanted a cleaner, simpler bill, and they may have gotten it, but it may come at the cost of some of our health professionals out there called APRNs. By authorizing APRNs, this is another comment made by our reviser, by authorizing APRNs to prescribe without a written protocol, but not amending other provisions, hear that, other provisions of the Kansas Nurse Practice Act to specify other acts that may be incidental or necessary for such prescribing, the bill may create ambiguity in the law regarding what acts an APRN may or may not lawfully perform. The Board of Nursing has broad authority to adopt rules and regs to regulate the practice of nursing. However, rules and regulations legally cannot contradict, they cannot contradict statute. Statute provides this basis of authority for rules and regulations, and statutes supersede rules and regulations. It was also commented, and you can go back and look at the conference committee, you'll see all these words, that the committee reviser expressed that additional amendments to other sections of the Kansas Nurse Practice Act may resolve the ambiguity in these issues, on these issues. It's interesting when you talk about allowing the authority to issue prescriptions, but it specifies that an APRN cannot dispense prescriptions or medicines. A doctor today can self-dispense, but it allows an APRN to request, acquire, and provide samples. Many times you'll see a doctor, when they've given someone a new script, they want to see how it works, they may give them a 30-day worth of samples or even 60 days, depending upon what that doctor needs to find out if this will work. Especially when it's some of the most expensive medications that we take, and it gives them an opportunity to try it without the expense. I was informed the other day that the physician assistants would also be requesting to come out from underneath CPAs. We've had the bill of the AAs and CRNAs, and some of the very people that are opposed to the AA CRNA bill are big supporters of this bill. And what the AA CRNA issue does is it says there is one health professional out here that we don't like and we don't want competing with us. I do realize that some of our communities do not have doctors. I do realize that the CPA can be an issue. And we offered to address those issues, and every time they testified before us, a CPA, 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 CPA was the thing that they brought up. They just call it a piece of paper. But if you take the time to go through the Nurses Practice Act, you will see it was not just a piece of paper. As you heard earlier from a representative that deals with the Healthcare Stabilization Fund, that Healthcare Stabilization Fund also has another little piece that's a benefit in it, because when a physician retires or sells their practice, and there may be claims that could still come in several years later after they have given up their malpractice insurance, the Healthcare Stabilization Fund kicks in. Nurse practitioners will not have this. It's also been said out there that we've talked about not having any minimum coverage for the malpractice. The minimum of malpractice is in statute for physicians. Why not for the APRNs? So if one is underinsured, what happens to him or her? What happens to their livelihood? What happens to their families? I know that most of you have made up your mind, and I get that. I've also heard the comment that, well, gee, I got 20 calls from my district. I didn't know 20 calls is what dictated how we voted. I've also heard that we need to put this issue to rest. It's very difficult to put something to rest and resolve it when individuals won't sit down and work with you in good faith. I have always, and some of the people that are on the side of this that I'm in opposition with are people I have worked with over the years and helped their clients get a compromise reached. One of them happens to be the physical therapist. We just did it with the occupational therapist. We did it with the practice of corporate medicine, but you have to sit down and you have to be willing to actually negotiate. And this became personal for me when friends on that other side stopping by. Longtime friends. But we don't vote because it's personal, because we may have a practice that we can sell to someone if we get independent. Or that we feel we want to put this to rest because we're tired of hearing it. If you think this issue is going to go to bed, you're wrong. It's going to come back up when there are problems. And by that time, it may be too late for the individual that asked for the change. I would ask that you not support this. You want true health care. You want the quality of health care. Think about the number of times that you have thought about some of the things that we have done in the Health Committee where we have changed the level for licensing with BSRBs and other nurses and other health professionals. And the one thing that I get asked almost every time when we do this is, you're lowering the quality of care. If you all remember the wheels that were put on your desk last week, 700 hours versus 12,000 hours. At one point, they thought 4,000 would be good. Now they say 700 is enough. I'll leave you with this. I'm sure you're really tired of hearing from me, but I thank you for the opportunity. And I pray that we don't have this issue come back and that it costs someone their livelihood. I ask you to vote no.
Representative Barker.
Thank you, Mr. Speaker. I've served on Health and Human Services for 6 years. This is not the first time I've seen this bill. And I've heard testimony every time we've had a bill. But there's I have a memory of two of those individuals that appeared. One of them was an APRN psychiatric nurse. She worked out in western Kansas. She had a collaborative agreement with a psychiatrist who is 82 years old. Her concern was, he's not going to continue to practice, and what am I going to do for my patients? She worried about her patients. She tried to get other collaborative agreements with other psychiatrists. Well, there's not many out in Kansas or out in western Kansas. She was going to have to go to Kansas City and get a collaborative agreement and pay that doctor, based upon her collaborative agreement, a large amount of money every month so she could see her patients. That's one. And I always, that's been about 4 years ago, and I wonder how that all worked out. But she was really concerned about her patients, as most nurses do. Not the doctors don't, but nurses, those are the first people you see. And they're in underserved communities, and our ranking member on health brought that up. They are in underserved communities. That's where we need them, and we need them in central and western Kansas. If we want a cardiologist, we'll come to Topeka, we'll go to Kansas City. Fortunately, we've got a couple in Salina. But one more story. I happen to go to the VA. I've always had an APRN. They have full scope of practice. One of them saved my life. I had a heart attack and didn't know it. And I had her for years. Unfortunately, she left the VA to go work at Fort Riley with wounded veterans. Doctors make mistakes. They do the best they can. We're all human, we make mistakes. APRNs are human, they will make mistakes. But when you look at this bill, it's got most of the coverage we need. I know there are organizations out there that doesn't want to give up any turf and want to have it all. But this is a reasonable solution to this problem. We get more people in the field. We allow them a full scope of practice without a collaborative agreement. And, there's some doctors that have 4 or 5 collaborative agreements with different APRNs. Not saying that's wrong, but it is you get a check every month. One of our APRNs had testified. She lives west of Salina. You folks think everything west of Topeka is western Kansas. But she was west of Salina. Her collaborative agreement was with a doctor in Kansas City. So I asked a question on health. I said, well, how often do you see him? She said, I haven't seen him since I signed my collaborative agreement 5 years ago. So this is just my opinion, and the will of the body will always, I'll always respect the will of the body, but I think this is a good deal. And there may be a tweak to it at some point in time. That's what we do. There's threats of lawsuits or whatever. Well, every bill we pass in this body is subject to that, unfortunately. But I would encourage the body to vote yes on this. I think it's a great bill. It's been around for 6 years. We passed it out. It would have passed this body in 2019. Unfortunately, it was gutted, and we put something else in it. So with that, Mr. Speaker, thank you very much.
Representative Neighbor.
Thank you, Mr. Speaker. I know this is April the 1st, so I'm going to say this, and I hope you don't think I'm joking. I agree with one of the representatives from Wichita who's on the other side of the aisle, and she and I are not always eye to eye. Representative, she's not even listening. Sorry about that. She didn't catch it. I said, I know this is April Fool's, but at this moment, I agree with the person on the other side of the aisle on this particular issue. That's not a joke. I come to you to say that because I've heard several people say, well, a little bit is better than none. When a life is there, when you can lose a life because of misjudgment, and I will tell you, nurses are gifts to all of us. They're like secretaries in a school building and the custodian. They are the lifeblood. When the doctor's not in the room or a teacher needs something in the building, that's who you go to. Those are the people that know the ins and outs and where the holes and the cracks are. But not everybody is trained to the same degree. As an administrative assistant in an elementary that was the largest in the state of Kansas, I didn't have qualifications to be a principal, but I knew where everything was when the principal didn't. What I'm saying here is the training that physicians receive is above anything that we're looking at today. If APRNs want to be physicians, they certainly have that right, and they've started that path. They can go back to college and become a doctor. That's not an issue. That path is open. But this bill does not contain the right amount of coverage and research, nor have the parties to this bill come to the table in earnest. I use as an example an earlier bill from insurance this year on PBMs and pharmacists. They were about as far apart as you could get. And this has taken, 4 or 5 years to bring them together. And we said, you might not like what we do if you don't sit down and talk this out. And we've done that many times here in this chamber. And it has been to our benefit, not to our detriment, because they had a working relationship. When people open the door to something and they don't have that kind of a conversation, the people that are hurt the most are the people receiving the services. Let's look at why we don't have enough people or doctors or nurses in Western Kansas or in rural areas. We don't have Medicaid expansion for 150,000 people, but that's not the subject today. If we had that coverage, we'd have hospitals. And we don't have hospitals in areas because do you know what it takes to set up a doctor's office or even a practice in a rural area or any area? You spend the rest of your life, unless you're in a partnership or you work for a hospital, paying for that. And in a rural area, if you don't have someone to work with and a hospital close by, why is someone going to come? We have closed multiple hospitals in the last few years. Multiple. And we have people in here that it's been hard on. But this is not the answer because it's not a complete bill. It's missing a lot of moving parts. And if a patient should pass and a person doesn't have enough malpractice, who's going to pay for that? Because the trust fund's not going to come back and pay for it. We need to think and take this bill back to committee and bring both sides together and arrive at a bill that in a year or two is going to come back and bite every one of us. And this is not saying nurses are good or bad or doctors are good or bad, because there are people in both of these professions that make mistakes. There are people in all of our professions that make mistakes, and we know who those people are. When we talk to them, we know who they are, and they may be our best friends. But there needs to be more in-depth coverage in this bill as far as malpractice insurance, number of hours, and maybe we should look and say, if we're going to put an APRN in an area, then they have to be committed to a rural area. If that's where we have the problem, we need to set those guidelines. Because if they start coming to urban areas and they're not going to rural areas, we have not solved any problems at all. I stand in opposition of this bill, and I hope we'll do more homework. Thank you.
Representative Epley for a second time.
Thank you, Mr. Pro Tem. Second and final time. I've got to get on record to correct some things that I heard that just troubled me, and I wanted to make sure we got it straightened out. Representative from Leavenworth made a good point about lack of access. Well, that lack of access is due to the fact that one of their hospitals closed. You don't have a hospital, you're not going to have providers there. They have a hospital in the south part of Leavenworth. My hospital's actually put a clinic there, and guess who staffs it? APRN, staffed under a collaborative practice agreement. It's working great, providing good access, better access for those folks in Leavenworth. It is really sad, that situation, because that's not your typical rural area. So I don't know how representative that is of the need for APRNs in the state of Kansas. I would kind of take issue with that. The second thing, and this really troubled me when I heard this, you know, when I heard from the representative from Sedgwick that 150 students in a KU class of about 200 are from out of state, that's completely wrong. That is incorrect information. I want to correct that on record now, because 90% of the students at KU Med Center are from the state of Kansas. That means about 180 of those students are from the state of Kansas. I've been on those committees that accept these students. Everybody we interview is from Kansas. They're from this state, not from out of state. How many of those kids get into primary care? About 50 of them, about 50 out of 200. They go into primary care. A lot of them go into family medicine. We used to pride ourselves in this state that we had, and this is a fact, we have everyone within 30 minutes of a family physician in the state of Kansas. Now, I don't know if that's true today, but that was true back in my day when I was a family doc up in northeast Kansas. So, you know, we'd have to run the traps on that and see, but I know we have a lot of family docs out in rural Kansas and throughout the state, and they're doing the best they can to provide the service. Third and final thing, CPAs. Oh, my goodness. Just sucking the life out of me. We're all about giving up on CPAs, but if we're going to do this, for goodness sakes, let's do it the right way. You know, let's have a defined scope of practice. Let's define what these folks are going to do. That was in the 2019 bill that we got and goed. I almost wish we could bring it back. But, you know, it's not there. There's no defined scope of practice. This is not ready for prime time. And there's no definition of malpractice. And who knows if they're covered by the Healthcare Stabilization Fund and whether your constituents will have coverage. They'll have protections as afforded through the Healthcare Stabilization Fund. You don't know that because it's not in the bill. So I urge you to not concur on this, and I appreciate the time as well. Thank you very much for the second time.
Does any other member want to discuss this motion? Seeing none, Representative Blex, you may close.
Thank you, Mr. Speaker Pro Tem. It's been a great discussion. I'll just highlight some things that there's been over 300 studies that indicate APRNs have safe practice. The patient outcomes are equivalent to doctors. Malpractice claims in the state of Kansas in 2020 was, or 2019, excuse me, was 1 in 1,000. This is based on actual malpractice or adverse events for APRNs, 45 per 1,000 with physicians. So they're not out there killing people. And there's no collaborating agreement in statute. That is in rules and regs. And we talk about hours. A physician is about 11 years. I'm not taking anything away from them. It's long, hard. Hospitals really use that almost slave labor, I'm sure, in that residency. But if you really look at an APRN, most of them now a 4-year bachelor's degree. They'll go a couple of years for their master's or even a doctor. So they're coming out with 5-7 years. So that's not totally exactly what we've heard. And I guess another thing that hasn't, we look at the collaborating agreement, the CPA, and I'll give you a story about that. I'm Southeast Kansas, and we like stories, and I know the doctor will appreciate this, but a young lady, APRN, I know, was working, went with her BSN, worked on the floor, worked several jobs, and each physician had to have a collaborating agreement, and that was fine. The physician was paying for that. That was part of the deal, and he was getting work out of her, and a physician hired her. He was paying the same thing, and now all that's required to be on file with Kansas Board of Nursing, that collaborative agreement, every one of them. And hospitals pay doctors. They can have physicians can have up to 6 APRNs they can supervise, and a hospital compensates those. This piece of paper that we're talking about that's phony, when this particular APRN went out on her own, she took a lab tech, a office manager, and an LPN with her. Real scary times. Bottom line was, she paid $1,000 a month. $1,000 a month. Imagine starting a new business, buying computers, payroll, and having to pay somebody $1,000 a month, signed a protocol, a collaborative agreement, never saw it again. Doctor was 80 miles away. That particular doctor that was a collaborating agreement, basically hospital bought him out. All of a sudden he called up and said, hey, the hospital's bought me out. I can no longer enter into a private agreement with you. Guess what happens? Without that private agreement, that clinic would have had to close. 4 people would have lost their job. 20 years of successful practice, 400 plus patients. You name me one profession that we do certification, schooling, and license, architects, doctors, lawyers, accountants that get all their schooling, get their license, and then have their physician, their collaborating agreement person, either retire, God forbid die, move out of state, or a hospital buys them out. Boom, they're out of business. Ridiculous. No other profession is subject to that. So that's a real life story. And being from Southeast Kansas, we're not too smart down there, but we do a lot of stories. I have 2 dogs on a farm. They're both Jack Russell Terriers. One dog's a little bigger. He has more pedigrees, has more training hours than the smaller dog. I spent a lot of money getting that dog trained, and he's good. He does a great job. He's well fed, usually gets a lion's share of food. And last week I noticed that larger dog laying out in the yard guarding a bone that I'd given the smaller dog. The larger dog was full, but yet he wouldn't share the bone I'd given to the smaller dog. The larger dog wasn't hungry, but he would not share, and I wondered about that situation. Why? And I finally figured out he did not share simply because he felt like he had more training, he deserved the bone. So the smaller dog was also a good dog, and he serves me very well. He's not as well trained as the bigger dog, but he assists with duties around the farm. He chases rabbits and vermin from my barn and garden, and much like the larger dog. But since the smaller dog doesn't have as much training as the larger dog, I only allow him an 85% reimbursement in food, which is exactly what the APRNs get when they have somebody comes into the clinic. And people coming to my house, they were actually very satisfied with both dogs. but most people seem to be more satisfied with the smaller dog because he spent more time with the people. And oh, by the way, I forgot to tell you my dog's names. They are Doc and APRN, and I'll let you figure out which is which. And this bill is ready for prime time. And Mr. Speaker Pro Tem, I move that when we pass this motion to pass this bill 2279 out, that we concur and with the Conference Committee report. And I thank you for the indulgence in my story. Thank you.
Body, you have heard the motion to concur in conference on House Bill 2279. This will constitute final action on House Bill 2279. The clerk will open the roll and you may record your vote. Has every member had an opportunity to record their vote? Clerk will close the roll. Does any member desire to explain his or her vote? Does any member desire to change his or her vote? Seeing none. 80 having voted in favor and 34 against the passage of House Bill 2279, the same having received a constitutional majority, the bill is hereby declared passed. Clerk will record the vote. Speaker recognizes Representative Hubert for a motion to adopt the agree to disagree report on House Bill 2466.
Thank you, Mr. Speaker Pro Tem. I move that the House agree to disagree on substitute for House Bill 2466 and that a new conference committee be appointed. And I will briefly explain that House Bill 2466 was a computing science bill. There's two bills that have been added. Actually, we put the 2505, the ACT bill, into 2361, which is the CTE bill. And so now there's those three positions. And again, I would stand for questions.
Is there discussion? Representative Stodgdell.
Thank you, Mr. Chair. First, I want to commend the House Education Committee chairperson. He did a fine job of steering this bill through our committee. We had some problems with it. We solved it. We did it on a bipartisan basis. And in my opinion, it was maybe the best bill that we passed out of Education Committee in the last 6 years that I've been on there. Everyone agreed with it. We did take it to Conference Committee, and the Senate came over and gutted the CTE portion of that bill. And the intent of the bill was to put together a pilot program that would where we could assess the success of that program across the state. We had school districts and so on across the state in the assessment portion of that bill, and the Senate came in, narrowed that down, basically destroyed, in my opinion, the assessment capabilities in that bill, and basically said, take it or leave it. And after all the good work we'd done in that committee on that particular bill, we should leave it. And let's go back to committee, hopefully, and get a bill out that we can actually agree on, not have one just stuffed in our face and say, take it. So I'm very much in support of this. Thank you.
Any further discussion? Seeing none, Representative Hubert, you may close.
Just real quickly, I can't disagree with what was just said, but the maker of this bill and then the representative who brought it to committee have both agreed that they want us to proceed. The time is short. If we're going to get this passed to the governor, which with the provisions there, that's important to do now before we wrap up, before we get done this, hopefully tonight, I would, again, renew my motion and close.
You've heard the motion. All those in favor signify by saying aye. Aye. Opposed, nay. The ayes appear to have it. Ayes do have it. Chair appoints Representatives Hubert, Thomas, and Stodgill as conferees on the part of the House. Are there announcements? Representative Woodard.
Thank you, Mr. Speaker. Democrats, we will have agenda immediately upon recess in 152 South. Thank you, Mr. Speaker.
Representative Rogers.
Thank you, Mr. Speaker. A conference committee between the House and Senate Ag committees will take place upon recess in room 159 South. We'll be conferencing on Senate Bill 261, the meat analogs. Thank you.
Are there any further announcements? Seeing none, Representative Hawkins.
Thank you, Mr. Speaker. Republicans, we will calendar in the old Supreme Court room immediately upon recess. Mr. Speaker, I move the House recess until 6 p.m. I didn't realize it was that late. Recess until 6 p.m.
You've heard the motion. All in favor signify by saying aye. All opposed, no. The ayes have it. The House is in recess. The House will be in order. Messages from the Senate, the clerk will read.
The Senate adopts the Conference Committee report on the following. Senate Bill 200, House Sub for Substitute, Senate Bill 286, Senate Bill 343, Senate Bill 453, House Bill 2239, and House Concurrent Resolution 5022.
Speaker recognizes Representative Ralph for motion to adopt the Conference Committee report on House Bill 2109.
Thank you, Mr. Speaker. My apologies, I got caught off guard there a little bit. Body, this is the beginning of 4 bundles from the Judiciary Committee. The first bundle, House Bill 2109, is what has been referred to within our committee as our records bundle. 2109 is going to enact the Charitable Privacy Act, as well as continue in existence several exceptions in the Kansas Open Records Act. Senate Bill 507 is the bill you see each year that addresses sunset provisions that are required in all exceptions to the Kansas Open Records Act. 5 years ago, 7 exceptions to the KORA were put into law. It's now time to review them and make them permanent. That's what Senate Bill 507 does, pass the Senate 39-0. The other bill in this bundle, House Bill 2495, that was is the Charitable Privacy Act, prohibits the disclosure of personal information from nonprofit organizations, passed our chamber several weeks ago, 107-13. Mr. Speaker, move adoption of the Conference Committee report and stand for questions.
Is there discussion? Representative Carmichael.
Thank you, Mr. Speaker. This is the only bill in the judiciary bundles that we're going to be considering within the next few minutes that causes me any concern, in particular relating to the nonprofit organization membership confidentiality. As I'm sure many of you know, this is a bill that is supported by the ACLU. It's supported by the NAACP. It is supported by a number of other progressive organizations. If you have concerns about dark money PACs, 501c4s, campaigning against people without any disclosure as to who their membership is, if you want to impede investigations by the Kansas Governmental Ethics Commission into these dark money activities, then this is the bill for you. However, I understand that a number of people on my side of the aisle have in the past voted for this legislation, and I certainly do not fault them for doing so, Mr. Speaker. Thank you.
Is there any further discussion? Seeing none, Representative Ralph, you may close.
Thank you, Mr. Speaker. I close.
This constitutes final action on House Bill 2109. The clerk will open the roll, and you may record your vote. An opportunity to cast their vote. Clerk will close the roll. Representative Landwehr votes aye. Does any member desire to explain their vote? Does any member desire to change his or her vote? Seeing none, 92 having voted in favor and 20 against passage of House Bill 2109, same having received a constitutional majority, the bill is hereby declared passed. Clerk will record the vote. Speaker recognizes Representative Ralph for a motion to adopt the Conference Committee report on House Bill 2299.
Thank you, Mr. Speaker. House Bill 2299 is going to create and amend law related to fingerprints. It's going to deal with surveillance of Kansas Department of Wildlife and Parks, jurisdiction of law enforcement officers, time periods for executing search warrants, and disclosure of information in child in need of care cases. In this bill, we include House Bill 2582, which directs DCF to share information with law enforcement. In general, we passed this bill passed our chamber 122-1 in mid-March. We also added the contents of 2508, which deals with retention of fingerprints for situations, employees, volunteers, and the like who are required to have background checks. We passed this bill 115-6. The Senate also did add a crime into this particular bill for the intentional disclosure of fingerprints and any records related thereto. We then also had two Senate bills that we added in that were passed through House Judiciary but were not heard on the floor. Senate Bill 435 expands jurisdiction of law enforcement officers, passed out of House Judiciary and then out of the Senate 38-1. We did make one tweak in conference committee to narrow down some scope of that expanded jurisdiction. And then finally, we also added Senate Bill 395, prohibiting parks and wildlife from conducting surveillance on private property unless authorized pursuant to lawfully issued warrant, court order, or subpoena in the United States Constitution. There's also addition of House Bill 2299 that increases the amount of time allowed for a search warrant to be executed from 96 hours to 240 hours. Mr. Speaker, I move adoption of the Conference Committee report on House Bill 2299. I'll stand for questions.
Is there discussion? Representative Carmichael.
Thank you, Mr. Speaker. If I might inquire of the carrier of the CCR. My notes are undoubtedly incorrect. I think you indicated that this has some implication of the bill about cameras and wildlife and parks. Could you refresh my memory?
Yes, we added Senate Bill 395, which was the wildlife and parks, ended up over in the Senate, came back to us through this conference committee.
Thank you for refreshing my recollection. For the information of my caucus, I did omit that from my description of the bill. The version of this that did come back is one which Wildlife and Parks said that they could live with because it actually only affects the trail cams, which they do not use. The bill is structured in such a way that it only pertains to surveillance by devices. And so I apologize. In preparing my outline, I missed that. Notwithstanding that, I believe that this is a good bill. I intend to support it. And I also want to take this opportunity to offer my thanks and commendations to the chair of the House Judiciary Committee as well as the committee staff who did an outstanding job of finding places for good legislation that the Senate never had time to consider. Thank you.
Is there further discussion? Seeing none, Representative Ralph, you may close.
Thank you, Mr. Speaker. I close.
Body, this constitutes final action on House Bill 2299. The clerk will open the roll and you may record your vote. Has every member had an opportunity to record their vote? Clerk will close the roll. Does any member desire to explain his or her vote? Does any member desire to change his or her vote? Seeing none, 110 having voted in favor and 3 against the passage of House Bill 2299, the same having received a constitutional majority, the bill is hereby declared passed. Clerk will record the vote. Speaker recognizes Representative Ralph for a motion to adopt the Conference Committee report on House Bill 2508.
Thank you, Mr. Speaker. This is considered to be the crime bundle from the Judiciary Committee. It includes House Bill 2362, which modifies elements of criminal penalties for abuse of a child, passed our chamber 124-0 back in March of 2021, last session. We also include House Bill 2447, provides for two-way electronic audiovisual communication devices to be used during preliminary hearings. This particular bill was heard in the Judiciary Committee. There were several suggestions in the legislation for modifications to the preliminary hearing. By amendment within the committee, we used or determined to use only the use of the two-way audiovisual communication for facilitating those preliminary hearings. Passed our chamber 120-2 earlier this year. We've also included House Bill 2674, requiring forfeiture of appearance bonds to be set aside in certain circumstances. That passed our chamber a few weeks ago, 121-2. House Bill 2697 makes changes to the process for evaluating and treating people who are undergoing evaluation for competency to stand trial. This passed our chamber earlier this year, 122-0. And finally, we include House Bill 2277, clarifying a definition of possession in our criminal code. That passed our chamber 116-8 in February of 2021. So again, that being last session. On that one, the chairman added in a notation here that we added an amendment on the floor when that bill was debated. The amendment would have excluded fentanyl testing strips from the definition of drug paraphernalia. The Senate was not agreeable to our amendment, so it's not included in this bundle, but there was work underway to try and include that through another committee. So, Mr. Speaker, I move adoption of the Conference Committee report on House Bill 2508 and stand for questions.
Is there discussion? Representative Carmichael.
Thank you, Mr. Speaker. The Vice Chair did his usual excellent and comprehensive job. I would like to address briefly HB 2277, which is contained within this bundle. The definition of possession at one time did cause me concern, and I voted no at the time. I am flip-flopping. I am convinced that this is, in fact, good legislation. It did include an amendment brought by the representative from Reno County that would have legalized the possession of fentanyl test strips. As the Vice Chair indicated, it was a Senate demand that that be stripped. Following the Conference Committee report, influential senators came to me and indicated that they believed that perhaps that should not have been stripped. I have been informed by several people that I think the Health and Human Services Committee perhaps has found a place for the fentanyl strips. Given those understandings, I certainly support this legislation and ask that you join me in voting yes on HB 2508. Thank you, Mr. Speaker.
Is there further discussion? Seeing none, Representative Ralph, you may close.
Thank you, Mr. Speaker. I close.
This constitutes final action on House Bill 2508. The clerk will open the roll and you may record your vote. Has every member had an opportunity to record their vote? Clerk will close the roll. Does any member desire to explain his or her vote? Does any member desire to change his or her vote? Seeing none, 113 having voted in favor and 0 against the passage of House Bill 2508, the same having received a constitutional majority, the bill is hereby declared passed. Judiciary Chairman would do well to read about Wally Pipp. All right, Representative Ralph on a motion to adopt the Conference Committee report on House Bill 2377.
Thank you, Mr. Speaker. I'd love to have a show of hands on who got the reference to Wally Pipp, but we'll do that another time. This is our driving and flying under the influence bundle. Last year we passed House Bill 2387 revising laws related to operating an aircraft under the influence, and House Bill 2377, which revises laws related to driving under the influence. House Bill 2387 passed our chamber 101 to 23 and passed Senate 40 to 0. House Bill 2377 passed our chamber 101 to 23 and passed the Senate 38 to 1. I would like to remind the body this particular legislation comes out of a result of a DUI committee that was appointed to operate under the auspices of the Judicial Council. It operated for 2 years. I believe it would cover 2019, 2020. I did want to at least acknowledge the efforts of that committee encompassing prosecutors, defense attorneys, judges, representatives from the AG's office, as well as representatives of the Department of Revenue and law enforcement. And the folks on that particular council did great work during those 2 years, presented some really quality legislation here, I believe, and we'll benefit from that for several years to come. The Senate made some minor updates in these pieces of legislation. And at this point in time, Mr. Speaker, I'd move adoption of the Conference Committee report, House Bill 2377, and would stand for questions.
Is there discussion? Representative Carmichael.
Thank you, Mr. Speaker. The Vice Chair has obviously done excellent work. I want to call your attention first, though, to HB 2377, the DUI reform law. What the Vice Chair failed to tell you is that he served as the chair of that Judicial Council committee. I was privileged to sit in and watch the way in which he brought people together on a very difficult issue. And by the time the Vice Chair was done, I believe there was virtually unanimous agreement. This is an example of the Judicial Council and the Legislature working together at their best. I also, though, want to call your attention to HB 2387. When this bill did cross this floor, there were 23 of us who voted no. The Senate 40 voted yes. I'll phrase this delicately. If you think flying airplanes while drunk is a good idea, you might want to vote against this. Thank you, Mr. Speaker.
Further discussion, Representative Murphy.
Thank you, Mr. Speaker. We talked about this in calendar. I understand this is just dressing up the legislation that's already there. I'm not here to try to talk to you about not voting for it or whatever like that. I just think we need to understand that the state has no say over the licensing of pilots and how they operate, and it has no say over their aircraft and how they're registered. So it just seems to be kind of a jump. I looked up real quick and I verified with one of the representatives in the back. I said, you know, if your doctor, you go into your doctor and your doctor's drunk, you realize that's not against the law. I give my doctor friends a hard time. I tell them, I say, you know, if they mess up, they can kill one. If I mess up, I can kill 400.
Is there any further discussion? Representative Carmichael for the second time. Feel free to use the buttons and lights without the whistle.
My apologies to the Speaker Pro Tem. I don't think he saw that I turned my light off and then turned it back on, because I did want to mention that the distinguished pilot who just addressed you a few moments ago has vastly more experience as a pilot than I do. I respect his ability in that regard, but both the federal government and state government have what is known as concurrent jurisdiction when it comes to operating aircraft under the influence of alcohol, and that's a well-established doctrine, and that people who do that foolish act can be prosecuted by either or both, and that's as it should be. Thank you, Mr. Speaker.
Representative Murphy for Sir rebuttal. Also for the second and final time.
just wanted to make it clear, it is absolutely not okay to fly drunk. And this shouldn't affect me because I don't drink anyway. But the bottom line is I just, might be a little irritation if I landed for fuel and somebody wanted to ramp check me and give me a breathalyzer.
Is there any further discussion? Seeing none, Representative Ralph, you may close.
Thank you, Mr. Speaker. I close.
This constitutes final action on House Bill 2377. The clerk will open the roll and you may record your vote. Has every member had an opportunity to record their vote? Clerk will close the roll. Does any member desire to explain his or her vote? Does any member desire to change his or her vote? Representative Blex votes aye. Are there any further changes of vote? Representative Lee votes no. Final call for changes of vote. Seeing none, 101 having voted in favor and 12 against the passage of House Bill 2377, the same having received a constitutional majority, the bill is hereby declared passed. Clerk will record the vote. Speaker recognizes Representative Owens for a motion to adopt the Conference Committee report on House Bill 2361.
Thank you, Mr. Speaker Pro Tem. Committee here, I have 2361. 2361 passed this House 122 to 1 earlier in the session. What this does is it authorizes the Supreme Court to adopt rules establishing specialty court programs. Those specialty courts, such as drug courts, mental health courts, veterans courts, that provide very specific services to those that are dealing with those issues and in the criminal justice system. We added to that the requirement for our Bill 2473, which removes the requirement that all district court judges in Douglas County serve on the Board of Trustees of the Law Library. Super hotly debated topic there. That passed the House 121 to 0. So with that, Mr. Speaker, I move that we adopt the Conference Committee report on the Senate substitute for House Bill 2361, and we'll stand for questions.
Is there discussion? Representative Heiberger.
Thank you. Speaker did an excellent job of explaining the bill. I think the specialty court portion could be a really great step forward for criminal justice in the state. And I think the stunning example of bipartisan cooperation between the representative from Tonganoxie and myself on the other bill deserves your support, so thanks. Please vote yes.
Is there any further discussion? Seeing none, Representative Owens, you may close.
Thank you, Mr. Speaker. Lottie, since this may well be the last time I have the opportunity to speak here from the well, I wanted to take the opportunity before I close to thank everybody for the opportunity to serve here over the last 4 years. I was elected in 2018 to serve my district, and what an amazing opportunity it's been. I have thoroughly enjoyed the relationships that have been built here, those of which I will never forget. I want to thank our leadership for the opportunity to serve in our capacity. As a chairman this year, what an amazing opportunity it was. So with that, friends, I say farewell, and I look forward to seeing you next session. Happy April 1st. I close.
This constitutes final action on House Bill 2361. The clerk will open the roll and you may record your vote. Has every member had an opportunity to record their vote? Clerk will close the roll. Does any member desire to explain his or her vote? Does any member desire to change his or her vote? Representative Heiberger votes aye. Representative Ballard votes aye. Are there any further changes of vote? Seeing none, 113 having voted in favor and 0 against the passage of House Bill 2361, the same having received a constitutional majority, the bill is hereby declared passed. Clerk will record the vote. Speaker recognizes Representative Williams for a motion to adopt the Conference Committee report on Senate Bill 58.
Thank you, Mr. Speaker. Senate Bill 58 would establish the Parents' Bill of Rights. This version of the Parents' Bill of Rights is 2 pages. It is the Senate version. It is not the 10 pages that we had on the House side. It includes those things that empower parents and increase transparency. It includes or enumerates 12 rights reserved by the state to our parents, those things such as the right for the care and direction and the education of the child, the right to health care as determined by that parent. It also prescribes or requires local boards of education to develop and adopt their own policies to guarantee parents' rights. And those policies would need to include how a parent can be informed and inspect any learning material. 2, how a parent can inspect and review all educational and health records associated with their child. 3, object to any learning materials or activities. So board needs to have a policy relating to how would a parent do that. And 4, the board needs to have a policy relating to how a parent might challenge materials or educational materials. It does define the terms of parents. So I'll stand for questions.
For further discussion, Representative Fairchild.
Thank you, Mr. Speaker. I just wanted to say that I had some concerns about the House version of this bill because I felt like it was written in a way that where there would be quite a bit of bureaucracy with the provisions in it that required it curriculum to be entered online, and I just felt like it was a little bit too extensive. But I feel like with this bill, it's a very scaled back version. It doesn't go nearly as far. There's nothing in this bill that requires curriculum to be posted online. And it basically just requires school districts to allow parents to inspect the curriculum. And so I feel like that's a reasonable thing to do. And I don't think that there will be nearly the cost or the bureaucracy with this bill that there was with the House bill. And I just had a lot of concerns about that House bill, but this is just a very simplified version, a 2-page bill that basically just encourages involvement between parents and teachers, which I think is a good thing. But this bill doesn't have all the bureaucracy, doesn't have the problems that I saw with the House bill. And so I will be supporting this bill, and I would urge everyone to support it as well. Thank you, Mr. Speaker.
Representative Sanders.
Thank you, Mr. Speaker Pro Tem. Will the carrier of the bill stand for a question or two? So under paragraph 5 or bullet point 5 of the Parents' Bill of Rights, it says the right to attend publicly designated meetings of the local school board and the right to question and address school board officials during designated public comment periods or through letters, electronic communications, or in-person meetings. So what I would like to know is, number 1, do school boards have to have publicly designated meetings? And if so, at such publicly designated meetings, do they have to have a portion of the meeting where it's a public forum where people have the, do they have to designate a public comment period?
Thank you for the question. I'm not an expert with COMA, Kansas Open Meetings Act. However, they do have to have a public meeting that may be viewed by those that are in attendance. However, they do not have to provide the public comment. They should provide the public comment, but it is not required by COMA in itself.
Okay, so then if they elect not to have a designated public comment period, then the options for the parent is through letters, electronic communications, or in-person meetings, one of those other three?
Yes, and that would be consistent right now, but they could certainly petition their school board, but that would be one avenue to make sure their voice is heard.
Well, I certainly have some heartburn with that. I think that the school board should be mandated to have public designated comment periods. That aside, I will be supporting this bill.
Representative Owsley.
Thank you, Mr. Speaker Pro Tem. To the previous speaker's inquiry about the transparency portal, that is coming. It'll be in 2567 is where you'll find that. Would the carrier of the motion stand for just a question? Section 1C6, the right to make health care and medical decisions for such child. How does that affect the vaccine mandates for attending public school?
The original House Bill 496 had a provision in it that said the right to make decisions regarding vaccinations and immunization. That was struck by the Senate, and so it is there for healthcare and medical decisions. I think someone may interpret that, and certainly in Kansas, I think that they would be correct.
So outside of the exemption for vaccines that currently exist for sincerely held religious beliefs, would this then expand that if the parent just didn't want that vaccine and it is their right to decline that, would that make this so?
I don't think that by passing this in statute would make the other requirements in statute nullified. So I actually do not think that. This is a very generic statement that affirms a parent's right to make medical decisions. It doesn't specifically speak to vaccinations. We have another place in statute that does specifically address that. So I would think that designation in statute would take priority.
I'll leave that interpretation alone for just a second. Did we find out what the school districts thought the fiscal impact of this to come into compliance with this bill would be?
So fiscal effect, you could perhaps measure it by each school district. I don't think it would be measurable. What you're trying to do is make sure that you have a transparent way in which parents can request information. That's what this does. It does not include any requirement for a website. So there is not an additional cost. And if there were an additional cost for each school district, I would say it was a very good cost to make sure that if a parent had a question and they requested information, it would be available to them. So.
Thank you for entertaining those questions. If there was an amendment offered in committee when we worked 2662 that if this is a good idea and it's transparent that it should apply to all schools everywhere. That amendment failed, barely fell. So I'd bring that up, that if this is a good idea, we could have made it for everybody, and I think that speaks to the fiscal impact of the school district. As far as the medical decisions for such a child, I'm not convinced that that's not a public safety issue or could become a public safety issue. In my opinion, this bill's not really about parental rights. It's about politicians making decisions for your children. It's about allowing special interest groups access to all the curriculum that your child gets. I didn't look at the Senate conferees for the Senate version of this bill, but I know in the House we had 6 proponents. 3 of the proponents were not even from Kansas, and we had over 60 opponents, ranging from teachers to parents. As mentioned in conference committee yesterday, I have yet to hear of a Kansas example where somebody, a parent, could not receive any information that they wanted from the school district. A lot of this is already occurring. I went through the report here. The right to direct education of that child. That's a little concerning to me as well. That's a pretty broad statement. We have professional educators in the state. I think we have some of the best. I would like to keep them. The right to request, access, and inspect all written and electronic records maintained by a school related to such child. I don't know about your school district, if you have children in your school district, but my school district oftentimes send me too many emails. I'm in complete contact with my school district. The right to be informed and inspect curriculum, instructional materials, and other materials that are available or taught to a child. This came up in conference yesterday too, that you could request a test and perhaps even ahead of time, and that child of those, whoever's requesting that test, could have an advantage over the rest of the class. As brought up now, I don't know of a school district that doesn't have public school board meetings. I know that when time is running long, sometimes public comment sections can be no different than our conferees in our committee rooms here, in that you have to limit the time. I went over the vaccine. Then it goes on to talk about any ideas or professed belief affirm that violates the Civil Rights Act. That's already a violation of the Civil Rights Act. It goes on, say pursuant to state and federal law. That's already state and federal law. It goes to say, be informed and have the ability to inspect any materials, activities, curriculum, syllabi, surveys, questionnaires, books, magazines, handouts, professional development, and training materials. This came up in our committee as one of the, I don't know if you'd call them conferees when it's just a discussion on an informational hearing, but there was a mother who had requested some professional development materials from a school district, and that district refused to give it to them because it was proprietary information. It was from a third party, and that school district could not provide that for them. This allows for the objection to learning materials and to challenge that materials, and I think this is where I really have a problem with this, because if that were to happen, then what about the other parents' rights to have that same material available for their child? You know, whose parents' rights are greater than the other? If I want my kid to be able to read this material, but you don't want your kid to be able to read this material, how do you get to take that away from my child? In committee, we had a discussion that it's also a parent's right to have the best teachers. And I currently think we do have some of the best teachers in the state of Kansas. And I don't believe that this is persuasive to keep teachers in Kansas. I think this is overburdensome and more busy work that they have. If we keep piling them on, they're going to experience burnout. I know that applications for our school district are down terribly. We're not at a teacher crisis yet, but we're headed there. And I think bills like this are just going to continue to put onto that. Last I heard, there are over 60 superintendent vacancies in the state of Kansas out of 286 USDs. Our school districts are struggling. It's been a hard pandemic, and the teachers have brunted some of the worst of it. I think that if we really wanted to support our teacher, we had this discussion in committee as well, that we could restore due process for them. We could fully fund our special education to where the districts would have that option to reduce class sizes and ease some of the load off of the teachers. I think there are things that we can do to benefit the teachers and school districts in the state of Kansas, and I don't think this is it. I would urge you to vote against SB 58. Thank you, Mr. Speaker Pro Tem.
Is there any further discussion? Seeing none, Representative Williams, you may close.
Thank you, Mr. Speaker. To address a couple points before I close, Tess, your school district would come up with their own policy on how to inspect materials, and that includes tests. If a school district says the test cannot be inspected until after it's taken, then that's what the school district would do. There's no requirement here. It is all local control. Second thing, objections to materials. If I personally object to materials for my child, I can't take that away from your child, my child. And the local school district would have policies relating to that. Third, we often talk about teacher responsibilities. I agree, they're vast and many. So I asked one of my friends that's a school teacher, I said, write down, please send me every item that you have to do, that you're required to do, and let's see if that's required locally, school level, school board, through accreditation, or the state. So we did it. And I had KSD review it. And this 3 pages of things that the teacher has to do in her district. Guess how many items we require? A tiny handful. So I definitely think the school districts and the accreditation process and the state school board should review all the things that they are putting on the backs of teachers, because it's probably too much. So with that, Mr. Speaker, I urge the body to stand with parents and affirm their fundamental rights to direct the upbringing and education of their child, and to adopt the conference committee report. I close.
This constitutes final action on Senate Bill 58. The clerk will open the roll, and you may record your vote. Has every member had an opportunity to record their vote? Clerk will close the roll. Does any member desire to explain his or her vote? Representative Clayton on an explanation of vote.
Thank you, Mr. Pro Tem. I vote no. Look on page 1 of the explainer and see the last bullet point. Challenge the material and educational benefit of any book, magazine, or other material available to students in the school library, the successful result of which would lead to the removal of the item from the school. That removes it from the school, not just from that child. Thank you, Mr. Speaker Pro Tem.
Further explanations of vote. Representative Penn, recognized for an explanation of vote.
Thank you, Mr. Speaker Pro Tem. Mr. Chairman, I rise in the strongest support of SB 58. In the House K-12 Education Budget Committee, our amended language unequivocally declared that throughout that bill, that parents have not a right, but the definitive right to direct, quote, the upbringing, education, care, and mental health of the parent's child. To raise our children, it takes their responsible parents, not provoking our children to wrath, but bringing them up in the training and the admonition of the Lord, as you see in Ephesians 6:4. The onus and the responsibility of our children's upbringing falls squarely upon the shoulders of the parents to whom their care, their training, their nurturing, their provision, and their very lives are entrusted. Our kids do not belong to the state, to educrats, to teachers' unions, or to the village. Our kids belong to their parents. Thank you, Mr. Speaker.
Further explanations of vote. Does any member desire to change his or her vote? Seeing none, 67 having voted in favor and 46 against the passage of Senate Bill 58, the same having received a constitutional majority, the bill is hereby declared passed. Clerk will record the vote. Speaker recognizes Representative Williams for a motion to adopt the conference committee report on Senate Bill 160. Representative Wassinger for a motion on Senate Bill 160.
Thank you, Mr. Speaker. The second conference committee agreed to remove the contents of Senate Bill 160 as amended by the House Committee on Agriculture and inserted the contents of Senate Bill 484 and passed the Senate 27-11. Senate Bill 160 would create the Fairness in Women's Sports Act and require interscholastic, intercollegiate, intramural, or club athletic teams or sports that are sponsored by public educational institutions to be designated based on biological sex. Mr. Leader, I move that we adopt the conference committee report for Senate Bill 160. I'll stand for questions.
Is there discussion? Representative Woodard for discussion.
Too late.
Representative Vaughn.
Thank you, Mr. Speaker Pro Tem. I stand opposed to Senate Bill 160. This issue is personal to me because my sibling is transgender. I think the most important thing for everyone in this room here today is to hear from more transgender Kansans about how this affects them. So I called Keaton earlier, my sibling, and I asked, what would you say? What would you say if you had the ear of 125 state representatives, and what would you want us to know? And they sent me the following message. I am a transgender Kansas resident. Every time these exclusionary bills are brought forward, it hurts us. We are real people, and this causes real damage. You are taking away our rights. The increased rates in suicide and depression in transgender youth are a result of not feeling accepted or embraced by society and their communities. The state of Kansas saying trans kids are other is reinforcing the message to teachers, classmates, and parents to exclude them. Sports are a way for kids to participate and bond with their peers. Singling out trans kids makes finding friendships and connections even more difficult. Trans kids are just kids. They need love, support, and the opportunity to grow into the best version of themselves. So I share that with you here today. And I know for many of you that this issue is likely hypothetical and is viewed through a political lens. But this issue is not hypothetical. It will do real harm to Kansas kids, and it will do real harm to my sibling. Instead of passing legislation that hurts a group of already vulnerable children, we should be passing inclusive legislation to protect marginalized groups. Instead of asking who can we exclude, we should be asking how can we create opportunities for everyone. And finally, as one of the women here who has most recently participated in high school varsity athletics, I would just like to say that this bill does not support female athletes. It discriminates against trans women. Trans women are women, and they deserve an equal opportunity to play sports in our schools. I ask you to please vote no on this conference committee report for Keaton and for all transgender Kansans. Thank you, Mr. Speaker Pro Tem.
Representative Wassinger.
Thank you, Mr. Speaker, and I thank the representative for her very thoughtful words, and I appreciate that. But what I want you to know is that this bill is all about bullying, discrimination, and exclusion. Only the bullying, discrimination, and exclusion is of young women. It's the total decimation of Title IX, and that's pretty personal for me. Biological men competing against women, it does not make sense. Let's look at Leah Thomas from Penn State, who had a major advantage going through male puberty. First of all, there's a 20-fold increase in testosterone when you go through puberty as a young man. You increase in aerobic power, fuel utilization, economy of motion, greater strength, larger body mass, greater bone density, increased muscle size, and cardiovascular capacity, all of which are very trivially affected by testosterone suppression. My choices when I was in high school were field hockey, pom-pom squad, and cheerleading. Title IX passed just before I graduated, and the women after me could play sports. Before Title IX, 1 in 27 women played sports. After Title IX, 2 in 5. That is a huge increase. Martina Navratilova said, when it comes to competitive athletes, sex segregation is the only way to achieve equality for girls and women. I quote Caitlyn Jenner, I respect Leah Thomas's decision to live authentically 100%, but with that becomes responsibility and integrity. We need to protect women's sports. Coaches at the collegiate level are judged based on their winning records. Why would they choose biological women when they have biological males that want to compete, who will help them win? And they'll be able to keep their jobs. I need to read to you the words of a female trainer and former collegiate athlete that I spoke to, and she asked me to say her words. But unusually enough, she asked me not to use her name because she doesn't want to be bullied for her views. She has a daughter, an athlete, and she said, do we tell trans females the hurtful lie that they can't cross category lines because they are victims of anti-LGBT hate? Or do we tell them the much less hurtful truth, that they are fortunate enough to possess a physical advantage that makes it unfair for them to compete against biological women in the very same way that it's unfair to have a 180-pound wrestler compete in the 140-pound category? This is not hate. This is fair sport. Crossing category lines in sport has always been considered cheating. She said Allison Felix's amazing 200-meter American high school record was set in 2003, was beat by 2,487 boys, high school boys, last year. Are you okay with the 2,485th 200-meter boy to win and break that long-standing record? As for those mentioning that the requirement for the testosterone level for trans female athletes, women, biological women who test 5.1 nanomoles in testosterone are disqualified, may not compete anymore. That's what happened to Mary Decker-Slaney. Trans females can compete at levels of 10, and the very lowest that they've ever found is close to 5. So they can compete way above the level that any young woman can do. This isn't hate. This is just unfair. Okay. Some may say that Kansas will lose millions of dollars because the NCAA won't come here. All but one state that had passed this bill continued to hold NCAA events. So that is a lie. And for saying that this is a solution to a problem and it doesn't affect them or their district, talk to the high school girls in Connecticut that had all their records smashed by 2 transgender women. Or how about the women on the swim team in Pennsylvania who lost to the gentleman that was in the 532 in the men's division, but what took the lead in the women's division? This is just not fair. I carry this bill for my granddaughters, Isabella and Grace, for all the young women who seek scholarships to further their education, and for all the young women that want to set records only to have them smashed by biological men. I urge you to vote yes for the wives, sisters, aunts, daughters, and granddaughters in your life.
Representative Samsel.
Thank you, Mr. Speaker. I want to start by acknowledging I appreciate that significant changes were made to this bill from last year's version. It eliminated many of the legislative findings that I found troubling. I also appreciate the discussions I've had with proponents of the bill. It was helpful and we reached agreement on many of the areas. But I want to focus on 3 concerns that I still have. The first one is about process. Last year we didn't get a committee hearing on it, even the committee of the whole. And we didn't get that opportunity again this year, and it's not just because we didn't have one, but that means we also don't have the opportunity to offer amendments or, in my opinion, improve the bill. There were some things passed around earlier. I'd actually read that before they were passed around, and I'm not going to go through any of that here, but one of them is the statement from the governor of Utah. There's a lot of stuff that I really like in there, but one of them is a quote from him, and it says, "I believe in process. How we make policy matters almost as much as the policy itself. An opportunity to participate is a critical component of public trust." I talked with the proponents of the bill, and one of those things we discussed was the CASHA policy that's been in place. I've had those discussions with administrators in my own district. If this bill included the CASHA policy or something similar to it, or something we could work out an agreement or compromise, this is a bill I could support. But until then, that's one of the concerns that I have. The other one is later in the bill where it's got attorney, and this is a smaller concern, but the attorney fee provisions and litigation provisions, where to me, it talks about direct harm or indirect harm, and then psychological, emotional, physical harm are, as a lawyer, very open-ended terms that I have concerns with. But maybe the most important one, and I'll wrap up here, but when we're talking about fairness, and I understand this is a very emotional and there's good arguments on both sides of this issue, but to use an all-out ban is something that I've really struggled with as I've thought about this bill. And one of the examples we've talked about is if you've got a group of girls, middle school, high school, something like that, they want to participate in track or volleyball, or maybe the tennis team. One of them is transgender. I have a very hard time saying every single time that should be an answer of no, they can't participate as they continue through their teenage years. If we use the CASHA policy, that can be addressed at the local level. In fact, I know it's been used successfully at the local level. So those are the concerns I wanted to share with the body. And I know this is a tough issue. The other thing I liked in the governor's letter, but he talks about using compassion, tolerance, and fairness, and I know that's something we all share in this body. So this is a hard one, but until those concerns are addressed, this is something that I couldn't support last year. I would like to be able to support it, but I still can't support it at this time. Thank you, Mr. Speaker.
Representative Clerk.
Thank you, Mr. Chair. Body, this is the second time I've been up here, and it's on the same bill. And the issues that we have here are the difference in biological makeup. It has nothing to do with the mental part of it. It has nothing to do with the desires of one person versus the next. It's a biological fact that males are stronger than females. And in my career, I spent 27 years at Drake University. It has a little track meet called the Drake Relays. I've seen countless numbers of athletes come through, male and female. I spent a number of years with the Olympic Committee. I spent time in Sheffield, England at the World Championships, in Barcelona, Spain at the Olympic Games, and in none of these athletic events that included males and females in their respective events did I ever see a female that could compete with males. And I don't care if it's in swimming or track and field or softball, it just doesn't happen. It's not because of any kind of separation. That was the biggest reason that years ago, female athletes were allowed or were made possible at the college level. I remember when we didn't have female athletes at Drake University. There wasn't a program. They developed the program at the university to give females the opportunity to compete with other universities around the country that had female athletics. So the notion that a female can compete at the Olympic or the professional level with males is just they're not capable. It has nothing to do with their ability. So I've seen some very, very good female athletes, tremendous athletes, track and field, swimming, tennis, you name it. There are a lot of very, very good female athletes. That's not the issue here. The issue is whether or not they can compete with the championship level of males. And it just doesn't happen. So I'll be opposing this bill again, and I would encourage you to do the same for basically the mental stability of our children, so that they don't have to compete with somebody that they can't possibly win against. Thank you, Mr. Chair.
Representative Clayton.
Thank you, Mr. Pro Tem. In something that will not surprise any of you, I stand in opposition to this bill for reasons that you might consider relatively cold-hearted. I represent, as you all know, a border district. I am the ranking minority member on the Commerce Committee, and when I make a lot of my votes here, I'm not necessarily thinking with my heart. I'm thinking with my head, and I'm thinking all about the bottom line. I would like you all, if you're interested in this, to go ahead and Google the business statement on anti-LGBTQ state legislation. You will see a list of businesses that has actually been updated as of today. I'm not going to read all of those because you would hate me even more than you already do, but I would like you to note that Cargill is one of those businesses. And so if you do support the meatpacking industry, as many of us purport to do, understand that voting for this type of legislation does make it difficult for businesses like them and other businesses to recruit and retain individuals. Some of you from my legislative class might remember a past piece of legislation, 2453, that allowed for major discrimination and some of the businesses that came out against it. I have spoken with a lot of our local chambers of commerce, and while they're not issuing exact statements in opposition, understand that we have a lot of difficulty when it comes to recruitment and retention of young people in our state. This type of legislation sends a bad message and is frankly awfully out of style. If you are a pro-growth, pro-business legislator, I would urge your strong opposition. And one final point that I choose to make is that a previous speaker indicated that men were physically stronger than women. Any man who believes that is welcome to meet me outside as soon as we have our next recess, and I will prove you otherwise. Thank you, Mr. Pro Tem.
Representative Woodard.
Thank you, Mr. Speaker. Will the carrier of the conference committee report stand for a few questions?
Absolutely.
Thank you. In your opening remarks or second speech, you mentioned the challenges and advantages after puberty. If that's the case, I'm wondering why this bill includes kindergarten and middle school students as well.
This starts early, and kids are going into puberty earlier and earlier, 10-year-olds, 9-year-olds, with whatever reason why, medically. It needs to be taken care of so that things don't go out of hand and continue in the same fashion that they did before.
I have a series of questions if you're willing to indulge me.
I am.
The bill defines, it references biological sex. Can you define what that is?
Sure. Can you tell me what a woman is?
Is the bill referring to karyotype, meaning chromosomes? Is it referring to anatomical biology, or is it referring to hormonal biology?
Females are women, are adult women that have the reproductive system of a woman, and the definition of a male is the same for them that have male reproductive systems. We would go by the birth certificate assigned at birth.
Okay. So what about those individuals that are intersex that have both reproductive parts that make up the same population as the redheads in our society today?
Well, the fact is that they are already protected by federal law. And the incidence of that is between 2 and 5 and 10,000. So they're already protected by federal law.
Okay. If a competing player from a different team chooses to challenge the gender of another player, how is that challenge going to be resolved?
It's very clear in the bill that it goes back to the schools and they get it figured out.
They get it figured out.
And they can also do some civil actions.
How do you figure out what someone's biological sex is then?
Their birth certificate at birth, not anything that's been changed.
So
They could produce a birth certificate.
So you want the bill to change the existing KSHA policy that they already have in place that allows for transgender athletes to play sports?
Yes.
Okay. So you would acknowledge that KSHA already has a policy that's dealing with this. From what I've been told, we are aware of one student in the entire KSHA system that identifies as a trans woman. Is that correct?
I believe that's true.
So we're going through this and potentially risking millions of dollars in legislation or litigation because of one student, which is, okay. Does the NCAA have its own policy to deal with transgender athletes?
Yes.
Okay. Do you happen to know what the position of the American Medical Association or American Psychological Association is with policy of allowing trans women to be able to compete on athletic teams with other women?
I do not.
They both support it. So I'm going to stick with medical professionals here. I think that answers all my questions. So
Okay.
thank you.
Well, thank you very much. I appreciate the questions.
You all, here we go again. We know the fate of this bill. We saw what happened last time. It's another year, another bill that is bullying children. Children that are among the most vulnerable members of our community. If this is focused on puberty and what people are doing in high school or college, why on earth does this bill target kids playing kickball, elementary students, kindergarten, asking them to prove it? Imagine asking your daughters or granddaughters to prove that they are woman enough to play sports. The real problem with this bill is its negative psychological impact on the mental health of young kids in Kansas. I said this last year and I'll say it again. This has never been about sports. This is a continued theme of attacking trans people in our state. First, it was barring trans people from being able to use the bathroom with stall doors that shut. Something so private and intimate that we want to regulate at what people are doing, but it sounds like we want to make state government small enough to fit into a bathroom or someone's doctor's office or their bedroom. Give me a break. Then it was banning them from our military, keeping them away from the lunch counter because they make people feel uncomfortable. These are people. These are our neighbors. And now it's keeping little kids from joining their classmates on the sports field. These kids want nothing other than to be able to fit in. They don't want to play sports. They just want to be able to play with their peers. Stop attempting to bully children so far into the closet that they are afraid to tell the rest of the world who they are. The very people that you're trying to put into the closet are the ones that I hope someday will be your successors in this building. To the young people that are watching, I see you, I believe in you, I value you, you belong here, and you always will. The people that you are potentially voting against today are your neighbors, the members of your community, friends of your family, friends of your children, friends of your grandchildren. Let's choose compassion, because compassion should win today, and we should always stand up against bullying children, especially when bills go down to targeting students in elementary school and middle school and beyond. Thank you, Mr. Speaker.
Representative Meyer.
Thank you, Mr. Speaker Pro Tem. This bill is also very personal to me as well. I don't know how many of you know this or if you heard my committee testimony, but I am the mother of a trans child as well. But I am also a member of the LGBTQ community and a social worker who primarily works within that community. This bill is just astounding in the way that it continues to legislate bullying our children. I know a lot of you disagree with that narrative, but the truth of the matter is that there are so few children in Kansas who identify as trans who we need to protect our female athletes from to even make this something that's codified. My 12-year-old child hears this, she's watching, they're watching right now, and with their best friend who has been trans since they were very young. They watch us up here and they wonder why we are trying to create legislation that hurts them, that bullies them. They feel terrible about the way that we are speaking about them and their identity. And this isn't just dress up, this isn't pretend. This is really who our kids are. And some of them are lucky enough to come from families that are affirming, that are loving, that are going to take care of them and make sure that even if they are different, they still have love and affirmation and a place to grow and thrive. What this bill does is it takes that opportunity away from our children. As Representative Woodard said, this affects kindergartners. My child is 12. They're in the 6th grade. This directly impacts them. They're in elementary school, and you are telling them and their best friend that they are not valid. We are legislating discrimination on a constant basis, and it's unjust, and it's just uncouth. This isn't some Rodney Dangerfield film from the 90s like Ladybugs, where we've got a well-intentioned, well-meaning coach trying to force someone into pretending like they're a girl in order to make the team better. That's ridiculous. That's fantasy. This is real life. These are real children. This is my child. And I'm going to stand up for them. I'm going to stand up for their friends. I'm going to stand up for their peers. I'm going to make sure that we continue to protect them from legislation like this that's only going to hurt them, push them into the closet, have them consider suicide, put them at higher risk for violence. And who knows what happens and how we really check to see if they're woman enough. I'm sorry. This is just wrong. And I urge you all to vote no. Thank you.
Representative Haswood.
Thank you, Mr. Speaker Pro Tem. As many of you know, I'm sort of a role model across Kansas for our younger folks, so I get asked a lot to do presentations, maybe even post a TikTok or two. And in those outreach and engagements to the young folks, I talk about our policies that we work on here in the People's House. And when I talk about LGBTQ+ issues and trans issues, and the comment section of young people are comments saying, I can't wait to move out of Kansas. This is why I hate Kansas. And this is what the young people see, this is what the country sees, and this is what the world sees. I stand here as a strong ally to our trans folks. And trans folks, You are loved. You belong in this world. Creator made you perfectly just the way you are. Trans women are women.
Representative Clark for the second time.
Thank you, Mr. Chair. Buddy, I come back because I made a mistake when I closed. I support this bill. I do not support the concept of it. Thank you.
Representative Susan Ruiz.
Thank you, Speaker Pro Tem. My colleagues, none of us should have to come up here today to ask that transgender kids ages 4 through 18 be allowed to live their lives just like all other kids. We see these same almost exactly worded bills introduced in legislatures all over the country. And you tell me why parents and their kids shouldn't think that they're being targeted for who they are. The Legislative Committee in Missouri heard the same bill on March the 1st. It was passed. And I keep wondering, what national group is promoting this hateful agenda? And why are people following them? As legislators, our actions have consequences. If you don't think these attacks of discrimination take a toll, you're sadly mistaken. Suicide rates among the LGBT youth are higher than the general youth population. And in fact, the recent bills passed in Texas have caused a spike in completed suicides, not just attempts, but children who have taken their lives. Transgender kids already go through so much as they work to live their lives authentically. Many marginalized kids look to band or sports, could be choir, could be so many other activities because they just want to feel included as part of a group. The legislature should find ways to be more supportive, understanding, and accepting of transgender kids' physical and mental health. The Kansas State High School Activities Association already has a procedure. There are policies that already have been in place for quite some time. We need to let that process continue. They know what they've been doing. There are a lot of steps that a child has to go through along with their parents, if their parents are, of course, supporting their child. There are a lot of procedures that they have to go through in order to be allowed to play in sports. We need to honor that and not try to step all over that. The reality is this bill is not about sports at all. It has nothing to do with sports. And you can continue to think about that, but it's not true. Because if you know where some of these bills are coming from through hate groups, then you know that this isn't about sports. This is about discrimination against children. I urge you to vote no on this bill.
Representative Humphreys.
Thank you, Mr. Speaker. You know, this is another one of the hard issues that we're dealing with today, and I suspect everyone in this room has made a decision on their vote. But in the event that someone is listening here or online, someone who is wondering if their voice is being heard, I have 3 reasons why we're doing this now. Why at this time? Some have mentioned to me, we don't have a problem in Kansas. I'm not sure if that's true or not, but that's not the point. Here's the point. One natal male competing with girls can change state records, can preclude scholarships for girls, can knock girls off the podium, can squelch dreams. And so we act now. Just this morning, our faithful staff went through every drawer in our desks. Why? Because proactive protection. We've never had an incident, as far as I know, in the house, but we act in advance. We wear hard hats in construction zones. In anticipation, we act now in order to alleviate difficulties later. Number two, the KSHA policy, which is on everyone's desk, defines gender identity as a person's deeply felt internal sense of being male or female. As we've talked about, there's no dispute. Science says biology matters in athletic competitions. So in order to help KSHA policymakers and courts understand the threat to female athletes, to women's sports, to Title IX, we need to ensure that no individual expert or policymaker can misrepresent the truth, that single-sex sport is the only way to preserve fair athletic competition for women. Finally, biological women, girls, our daughters, granddaughters, that is who is marginalized. When we don't talk about the issue, we need to talk about the issue. We need to find a way to include everyone. Just this morning, I met Miss Kansas Teen in the Capitol. She was so sophisticated and graceful at 13 years old. Yesterday, we celebrated women in a lovely way. My son works for a woman-owned business that gets tax breaks, Best Actress, Woman of the Year. Those are other examples I'm not bringing up because we're talking about sports today. Women, we've come a long way. Let's not go back. Let's figure out how to include everyone without harming biological girls and women. Level playing field. I urge you to vote yes.
Representative Byers.
Thank you, Mr. Speaker Pro Tem. Will the carrier of this stand for a couple of questions?
Absolutely.
When you were speaking a few minutes ago, you mentioned the trans girls and the cis girls in Connecticut. Can you tell the body what happened 8 days after the lawsuit was filed against the Connecticut Athletic Association?
I don't recall at this time. I'll have to pull that up.
Within 8 days after the cisgender girls filed a lawsuit against the Connecticut Athletic Association, one of the plaintiffs, one of the cisgender girls, beat both the trans girls twice, 2 different races. So while we can talk about this being about athletics, the reality is it isn't. The reality is, out of what looks to be reported as 42,000 girls in athletics in Kansas, and we realize it's not an accurate number because multiple sports are counted multiple times, there is 1 trans girl. Maybe. Maybe. So if that is the case, and we have yet to see any trans girl making the newspapers anywhere in Kansas for athletics, why do we have this? Why is this bill even here? And we can talk about prevention. And it's interesting that this body has spent an inordinate amount of time speaking about mental health prevention and how important it is. Yet we will put this out here to challenge those kids who are trans girls in the state on their mental health. In a recent survey, 85% of transgender and non-binary kids were answering the survey, 85%, a survey of nearly 1,000 kids, reported that just having the debate on these bans on trans kids has had a detriment to their mental health. 85%. And so we do this over and over and over again. We know that when Idaho signed this into law, it only took a few months for it to end up in federal court and that law to be stayed. We know that when Tennessee signed this into law, 6 months later, it was in court. We know that when West Virginia signed this into law in April, that the federal courts, of 21, I should say, federal courts blocked it in July. We know that when Florida signed this into law in June of last year, that right now a federal court has put a stay on its application while they're hearing a different case involving transgender kids. So once they've got that decision, then they'll come back and revisit this one. It happens over and over and over and over again. And why? Why do these bills keep coming up? Is it because the acceptance of people like me, whether they are 4 years old or 59, means that we're moving into a new world, that we're moving into a new understanding of humanity? And if that acceptance represents the future and the now, then those people that reject that, those people that reject me, the people that get on the elevator with me and then move away from me, like I'm unaware of that. If that happens, those people, do they represent the past? And if you were living in the past, how scary is that? And so a fearful reaction, such as attacking trans kids, which interestingly enough are not in this room. Why do we do this? When this bill was heard in the Senate, there were 11 proponents. The majority of those proponents, attorneys. There were over 100 opponents. Parents, kids, teachers. The people are ready to move beyond our politicians on this. When presented with the facts that the NCAA, whether it be one sport or 90 sports, have policies in place dictating what happens for a trans female to be able to compete, and that the local, state level, high school association has a policy in place that dictates how trans people can be involved, 71% of people say, why do we have this legislation? We don't need it, it's already covered. And yet here we are, debating this. My previous world, my previous career, I spent 32 years in the classroom. And has been mentioned over here a number of times. During that time, we were in service numbers and numbers of times to talk about bullying. This is the definition of bullying. It's an aggression action taking place from an imbalance of power, whether real or perceived. And it has the ability to be repeated or actually is repeated. Well, let me think. We saw this bill last year. This one's stripped of all the magazine references and everything, but it's still the same language as the bill. Saw this last year. We're seeing it again, repeated. An imbalance of power, one trans girl versus the Kansas State Legislature. Is that not a perception of an imbalance of power? Aggression? We have yet to see any trans kid excel in a sport here in Kansas, and yet we're going to go after them anyway, just in case. How do you get beyond the bullying? And for kids who face the emotional exhaustion day after day after day of trying to live their authentic selves, bringing themselves into the light, being the person that their God knows that they're created to be. Because after all, man sees the outside, but God knows the heart. Being that person, walking in that light, in a world that looks at them and says, you're not welcome here because you're different. And to be told you can't be a girl because you don't have all the same body parts. How many people have ever heard, you be pretty, your face is so pretty, why can't you just do something about the rest of you? Would you smile more? If you smiled more, you'd be more attractive. We're really good about setting up these standards over and over again. And then we're looking at trans girls and saying, sorry, you're just not girl enough. That's what it is. When people referenced Leah Thomas as he and him, I wonder, what do you say about me? What do you say when I walk down the hall? How do you refer to me? And the simple fact that we're hearing this now, the end of March, the first part of April, and every one of these bills comes in at the end of March, first part of April, in state legislatures across this country, and the Trans Day of Visibility is the last day of March? Is it intentional or just happenstance? When I ask about Leah Thomas, if I ask you what events did she participate in, and you said to me the 100, the 200, and the 500, and I ask you meters or yards, do you know? How much involved in women's sports are you really? By the way, it's yards. If I ask you that Leah Thomas's win in the 500 yard, where she took first place in the NCAA, what is the difference between her time and the record time set by Katie Ledecky? How many of you would know that she is nearly 10 seconds slower than Katie Ledecky? And how would you know, too, that while Leah Thomas is sometimes referred to as hulking at 6'1", Katie Ledecky is 6 feet tall. Missy Franklin, who holds the record in the 200, is 6'2". Where's the biological advantage there? Earlier, the question was posed, how do we define biological? Is it based on the karyotype that we carry? How many of you know what your chromosomes say? Do you know if you're XX or XY for sure? And that's not a rhetorical question, because most of us don't know. And what endocrinologists tell us is that we're a lot more diverse than we think we are. And if it's not karyotypes, is it hormonal? I'm probably the only person in this room that knows what my hormone count was before I did transition. My testosterone levels were 6 times lower than the average male's. Happens. And I know what they are now. And they're well below 5 nanomoles. So we're going to sit here and debate this and come up with all these different ideas. Matter of fact, most of us walked in the door right away with our already made up what we're going to do on this. And we're going to play games with kids. We're going to let them be political pawns for whatever advantage we can get out of this. When this is over and we go on break, I will go to my house and there will be families that come to my porch and look at me and say, can you tell us it's going to be okay? Not just some number somewhere. Names and faces, people that I know. You heard from our colleagues that have siblings. Many of you in this room, you have members of the LGBTQ community in your families. They're not just your neighbors. They're nieces and nephews and cousins. And for those of you that talk about your grandchildren, my grandparents had no idea about me. How would I have ever told them if I ever thought they would have rejected me before I even got a chance to open my mouth? How could I have gone and tell them, there's something you need to know about me because I'm hurting and it's dark in here? Because not being able to be your authentic self, you spend your time walking in the dark. And if you happen to be a person of faith who's told to walk in the light, yet your life is in the dark, and there's not even a parental hand to hold to tell you it's going to be okay, we can get through this together. When we vote on this, I hope you vote with your backbone and your conscience, and not just with your party, and not just with the perception of who's going to support you and who's not. Because I promise you, your constituents write me. And those letters start with, I would tell my representative, but they won't listen. But you represent me, even if I'm not in House District 86. You have a chance to make a difference in everyone's lives. Or you have a chance to make it about yourself. That choice is yours. You need to decide, are trans women really women? Are trans girls really girls? And for every example of, well, you know, you don't have a uterus, there are women who are natal that don't have uterus. You don't have the background of growing up as a girl. There are plenty of people in this world who were raised as boys because their dads didn't know what else to do. We all have a different background, and none of us are the same. None of us are similar. As much as we want to say, there's uniqueness to all of us. And the uniqueness of someone who is trans is amazing because they get to live a life where they see things from different perspectives, with different expectations. And the courage that it takes for them to stand and be themselves in a world that seemingly does not want them is incredible. It's much higher than pushing a button when we get finished with this. So I hope that when we do close this, that you will vote no.
Representative Lee.
Thank you, President Pro Tem. You know, I was in the back of the room and I was just praying, Lord, give me grace, give me kindness, and give me empathy, because this is a hard debate. And there are so many on both sides of the aisle that, well, I like you. But we can't be afraid to talk about truth. And I was listening to the previous speaker, and everything that they were saying, we can flip that. How many girls, little girls, have to die, have to be bullied in school, and for us to make this argument okay that we don't need to protect them, a biological girl. You know, I didn't have any plans at all to speak on this bill, but as I listened to some of the speakers, I just started writing. And you know, here is what I came to. This issue is personal to me because I'm a woman and I like being a woman. I don't view this through a political lens. I view this through a biological and religious one. Recently, Ketanji Brown Jackson, nominee for the highest deciding court in the land, a liberal Democrat, was asked what the definition of a woman was, and her response was, I'm not a biologist. Her answer was correct in that a woman is based in biology, and it makes me sad. It makes me sad that the women in the room don't realize that we biological women are being bullied. And we talk about that so much. We are so anti-bully. We do everything we can to protect those being bullied. And I feel bullied. And I'm offended. I'm not just merely a bleeder, as some in society refer to us biological women as. I'm not just a pronoun or a political talking point. I'm a creation of God. And as the presentation of the celebration of women from earlier this week, which I appreciated so much, I ask you to vote against the bullying of my biology and give me the RESPECT that we danced about on the floor. I mean, I didn't dance, but some of y'all did. The women, especially on the left, do a great job, as illustrated by earlier today, when one of your own was wounded. You do a great job supporting each other. This push for biological males to infiltrate my lane, our lane, is bullying and discrimination against me and my daughter and your daughters. I ask you to vote against this, not because we are the big, bad, ugly, mean Republicans, but because, or Democrats, but because there are little girls that are waiting for us to protect them too. Thank you, President Pro Tem.
Does anyone else wish to speak on the motion? Seeing none, Representative Wasker, you may close.
I want to thank my fellow representatives for a spirited debate and belief in their own thought process. This has nothing to do with lesbian, gay, or bisexual athletes. It only involves the issue of trans females competing against females in sports. My heart aches for any child that hurts. Believe me, doesn't matter who they are. With that, Mr. Speaker, I close.
Body, this constitutes final action on Senate Bill 160. Members will be in their seats. The clerk will open the roll, and you may record your vote. Has every member had an opportunity to vote? Clerk will close the roll. Does any member desire to explain his or her vote? Representative Arnberger on an explanation of vote.
Mr. Speaker, I vote yes on Senate Bill 160. Yesterday, we heard from 8 female legislators sharing Women's History Month facts, and I found it truly inspiring. Women have had to work hard for where we are today, and I don't want to move backwards and lose those accomplishments. I proudly stand up for those female athletes and ask that you do the same. Representative Arnberger Blue.
Representative Penn on an explanation of vote.
Mr. Speaker, I vote yes in strongest support of Senate Bill 160. As you can see, framing of this discussion matters. As the grandson, son, and husband of a woman, and as the father of 2 young women, this man proudly stands to protect our women and our women athletes. As the father of 2 girls, I want them to reach their fullest potential, compete in the fields of friendly strife with the utmost integrity, and achieve the victories for which they work hard and deserve. Let us neither erase biological girls, women by replacing them with biological boys, men, erase the opportunities they can achieve on any field or level, nor place them in unfair competition with biological boys and men. Let us create and safeguard fairness in women's sports. Representative Penn.
Representative Lee on an explanation of vote.
I vote yes for SB 160 in strong support. In my earlier impassioned speech, I misspoke of my intended position. It's been a long day.
Further explanations of vote. Representative Sawyer for an explanation.
Mr. Speaker, the state of Kansas should never condone bullying of our most vulnerable, marginalized communities. 160's veiled purpose, 160, veiled purpose is to bully transgender girls back into the closet. Their mental health is considered collateral damage. The cowardice of leaving enforcement to Kansas State High School Athletics Association is appalling. CASA will have no recourse other than creating policies involving intrusive genital inspections. CASA will become a legislative surrogate to impose our will on other people's children. It doesn't meet the 3 criteria typically used in human rights legislation. It isn't reasonable, necessary, or proportional. Trans girls are girls. I vote no. Representative Byers, Clayton, Hoy, Carlin, Ballard, Shue, Keither, Gartner, Amix, Neighbor, Reese, Poskin, Sawyer, Stogstall, Meyer, Weigel, Miller, Ohabisam, Osman, Carmichael, Alcala, Woodard, Curtis, Heiberger, and one more.
Are there further explanations of vote? Does any member desire to change his or her vote? Representative Highland votes aye. Any further changes of vote? Seeing none, 74 having voted in favor and 39 against the passage of Senate Bill 160, the same having received a constitutional majority, the bill is hereby declared passed. The clerk will record the vote. Are there announcements? Representative Woodard.
Thank you, Mr. Speaker. Democrats, we will have agenda immediately upon recess in 152 South. Be sure to get pizza on your way down. Thank you, Mr. Speaker.
Are there further announcements? Seeing none, Speaker recognizes the Majority Leader.
Republicans, we will calendar in the old Supreme Court room immediately upon recess. Be sure to grab your pizza as you go by. And Mr. Speaker, we will recess until 8:15 p.m.
You've heard the motion. All in favor signify by saying aye. All opposed, no. The ayes have it. The House is in recess. The House will be in order. Messages from the Senate, the clerk will read.
The Senate adopts the Conference Committee report on House Substitute for Senate Bill 267.
Speaker recognizes Representative Adam Smith for a motion to adopt the Conference Committee report on House Bill 2239.
Thank you, Mr. Speaker. I move to adopt the Conference Committee report for Senate substitute for House Bill 2239. Body, this is a taxation bill that contains property tax provisions, sales tax provisions, and income tax provisions. Mr. Speaker, with that, I'll stand for questions. No, I'm just kidding. Mr. Speaker and body, this is my first bill to carry this session down here, and boy, am I going to make up for it now. We have several provisions in this bill, and I think the best way to go through this is to identify them, kind of go through all the property tax provisions, income tax provisions, and sales tax provisions, just to try to maintain some consistency here. The first item has to do with the revenue neutral rate, changes to that policy, maybe otherwise known as Senate Bill 13 from last year. If you remember that, toward the end of the year, we passed a provision that establishes a revenue neutral rate for your property taxes. Essentially, you calculate that by taking the amount of money that the ad valorem property tax raised the prior year. You divide that by your new assessed valuation. That gives you what your mill levy should be. If there's any increase in that mill levy above that, it triggers what's called the notification and hearing process to give taxpayers some understanding on what property taxes are going up, which entity is raising your taxes, and by how much. Some of the changes that we made, it was brand new language. We knew we weren't going to hit it out of the park on the first try, so we knew there would be a trailer bill this year to correct some things and adjust some things, and here it is. First item it does is it establishes a complaint process for taxpayers. If you need to file a complaint, if you don't believe one of your tax districts, your city, your county, township, there's multiple different tax districts on your property tax statement, schools. Follow this process correctly, you can file a complaint with the Board of Tax Appeals to see if they did actually follow the procedure correctly. It also establishes a provision there where the county clerks can reduce the amount of property taxes to be levied by the taxing subdivisions back to what the revenue neutral rate should be if it's found that they did not follow the process. Obviously, when there's so many deadlines in statute, sometimes even mistakes happen, typos, things don't get published correctly, and this just gives them a provision to go back and say, okay, we made a mistake in the publication or whatever the error was, we can now just reduce that to the revenue neutral rate and continue on our budget process for the next year. Another provision of this is last year when I had an amendment to make this the same playing field for all entities. One provision that got pulled into that was the 20 mil for schools. This is a statutory mill levy. Your local school boards have no control over setting what this mill levy is. And it was not my intention to have increases due to that fixed mill levy actually trigger the requirement for the notification and hearing process. So we put an exclusion in there. The 20 mil still shows up on your statement. It just won't be the sole reason for triggering the hearing and notification process. Moving on to a residential property tax exemption, again dealing with those 20 mils for schools. Currently in statute, there's a $20,000 exemption. You basically pull $20,000 off of your appraised value of your home when you're calculating your assessed value for property tax purposes. That $20,000 has been in place since 1997. It's been 25 years since it's been changed, and we are increasing that to $40,000. If you actually went back to 1997 and increased it for inflation, it would be $65,000 now. That fiscal note was just a little bit too much. Doubling it to $40,000 is still a fairly hefty fiscal note, but it's $42 million of property tax relief to all Kansans and all residential owners. Moving on, we kind of had a technical change on zoos and agritourism land. I wasn't aware of this, but if you're a zoo that is privately owned, not privately or commercially owned, but not a municipally owned zoo that is property tax exempt, your entire zoo is classified as commercial property by square foot. All the pens and pastures, the exhibit areas. So what this does is that it allows the Department of Revenue to classify those pens as ag land. Obviously not production ag land, but it puts them into that division. Obviously, if you have like a gift shop or retail areas, that is still defined as commercial property. But it cleans that up a little bit. We have 29 Class C zoos in the state. 19 of those are owned by municipalities or public entities that are tax exempt. There's only 10 zoos that this would apply to. Department of Revenue's estimated this to have a zero or negligible fiscal note. Another technical change is on the grassland conservation program at the federal level. Currently, I'm pretty familiar with western Kansas. We have a lot of grassland or farmland in what's called CRP. It's the Conservation Reserve Program. It's when you take existing farmland and you plant it back to grass for conservation purposes. Maybe it was ground that never should have been farmed in the first place. It had too high of a slope or too steep of a slope. It's highly erodible, wind, rain erosion. So you can plant it back to grass, but under current Kansas statutes, that land is still valued as farmland. Now with this change in the federal code several years ago, establishing a grassland conservation program, that immediately conflicted with the state statutes that we have in Kansas, to where if we have grassland that is enrolled in this program, it's grassland that's never been farmed before, but if they enroll it in this program, according to Kansas statute, you now have to value that grassland at the farmland price, which is about 10 to 15 times higher depending on your region in the state. So this is a kind of a technical change to adjust for those changes at the federal level. Another property tax provision is an exemption on antique utility trailers. This is a very small impact, no fiscal note or very negligible according to Department of Revenue. Any antique trailer, a small utility trailer over 35 years old, is property tax exempt. All of the registration and licensing statutes still apply, similar to what they do now. We also have a personal property tax proration. This is similar to the way vehicles and watercraft are prorated. If you buy something or sell something in the middle of the year, those personal property taxes are prorated. We're just establishing that same formula to personal property. An important provision of this bill dealing with property tax is disaster-destroyed property tax abatements. This is at the county level. And what this does is this establishes authority for the county commissioners to abate all property taxes for buildings and ag improvements listed as real property. If the damage due to natural disaster is more than 50% of the market value, allows the county commissioners to go in and abate those taxes. Just a real world example. We had some wildfires back in December. The wildfire destroyed fencing sales tax exemption is also in this bill a little later on. But imagine that situation where your barn burned down or something happened like that, and then boom, you get a property tax statement, and you have to pay all your property taxes even though that barn no longer exists. We're just trying to create some fairness for those people. Obviously, if they rebuild the structure, then that new building goes back on the property tax rolls, but we're just trying to allow the local county commissioners the authority. It's the optional, it's not mandatory, optional authority to abate those property taxes and provide a little more relief for people that have been affected by disasters. That provision also is retroactive back to tax year 19. We've had several bills fires, tornadoes that have impacted communities, and we wanted to reach back to 2019 to allow property tax relief for those provisions. Just because we didn't get the bill passed doesn't mean that assistance still isn't necessary. Next item on property taxes, actually our last item on property taxes, is a telecommunications and railroad equipment adjustment to that current statute to include also inventory and work in progress. Currently, if you have a project, a rail project or a telecommunications project, these things are massive projects. They'll collect inventory for the project, they'll get all the supplies, all of the machinery and equipment in place to work on that project. It might be a 2-year project, might be a 3-year project. As soon as that is placed into service, it's property tax exempt. But when it's sitting there, stockpiled, ready for the job, it's on the tax rolls. This simply creates an exemption to say, hey, this is material that's going to be used in production and in service. Let's go ahead and exempt it now, just like it's in service. The fiscal note was estimated only at $100,000 on this item. Moving on to income tax. For those of you that might still be awake, there's a few back there. We'll start off with the SALT Parity Act. SALT stands for State and Local Taxes. Thank you. This has to do with some provisions from the federal 2017 Tax Cuts and Jobs Act. Kansas has never taxed pass-through, well, I shouldn't say never, I'm not sure, but currently they do not tax pass-through or flow-through entity income. When that income flows directly to the owners or the shareholders, it's taxed at the individual level, not the business level. This creates the option for that business entity to elect to tax it at the business level. It creates the ability for them to realize those deductions and income tax deductions at the federal level rather than at the state level, because at the state level, there's some limitations on how much you can deduct from your federal tax codes. This has a 0 fiscal note because the rate for that business entity is set at the highest rate, the 5.7 rate on income, the individual income. So it actually has a 0 impact on state revenues because we're just taxing it at the business level rather than at the individual level. Moving right along to the technical college and community college contribution credit. This is a bill that passed the House, I think it was House Bill 2315. Yes, passed last year, 119-4. This establishes a 60% non-refundable tax credit for technical colleges and community colleges. When it passed the House, it was just for technical colleges, and it was capped at $3.5 million. It went over to the Senate. They included community colleges in it as well. There are specific purposes for this. It's for capital improvements, deferred maintenance, or technology or equipment purchases, and the new cap is $5 million. It does expire in tax year 2026. We also established, there was a bill in the Senate that establishes a historic site checkoff. Again, this provision has a 0 fiscal note to it. It simply creates a little checkoff program on your individual K-40 tax return to where if you want to make a donation, you can specify which state historical site you want that donation to go to, and it is handled at the state level. The money goes directly to the historical site. It doesn't go through the Kansas Historical Association. Moving along to the short line railroad tax credit. This is an $8.7 million tax credit. It is capped at $8.7 million for 10 years. It is a 50% tax credit. This is a program that is designed, or we're implementing it to try to help the short line rails get their tracks back up to serviceable standards. When we had the hearing in tax committee, we had a conferee that came up. They brought up a big chunk of rail, a brand new piece, and then they brought up a chunk of of used rail, and the differences were significant, but there's a lot of maintenance that needs to occur on our short line rails that bring grain and all the products to all our ports from our consumers, our elevators across the state. This does have I think I said it's a 10-year sunset. It is limited. The way that we got to the 8.7, it's limited at $5,000 per mile for maintenance and improvement. Oh, the House did put in, it's limited to Class 2 and Class 3 railroads. The House specifically excluded the Class 1 railroads, which is your very large railroads like Union Pacific, Burlington Northern. We wanted to make sure that this money was going to benefit specifically the short line rails. We had this question in our Republican caucus on whether or not this is just limited to those businesses. This is transferable, but it has to be transferable to an eligible participant, and that is someone who is a customer. It's defined in statute as a customer of the short line rail, so it could be an elevator or a co-op or somebody that uses or contracts with the short line rail. That is the only eligible person that can receive that transfer. Moving along, we have a aviation and aerospace tax credit program. This went through House Commerce. It is limited at it's capped at $7.9 million currently. No new tax credits are issued after the tax year 2026. There's a lot of provisions to this program. I can go through them if there's specific questions, but ultimately this is a business incentive to try to recruit and retain our finest aviation students into the industry in Kansas. We're trying to recruit them and give them incentives similar to what other states have done. I know there's a lot of statistics and testimony. We didn't hear that in tax. I know Commerce heard extensive testimony on the benefits of this program. That never got through, so we included it in this bill in conference. Next item we had was teacher classroom supplies income tax credit. This is an eligible teacher is any public or private school teacher residing in Kansas. It is a maximum of $250. It's on their income tax. You do have to save your receipts. This is a non-refundable tax credit. You apply for this. If you're ever audited, you'd have to provide your proof of claiming that. This fiscal note on this one is estimated at $10.4 million, but Department of Revenue assumed that every single teacher in Kansas that qualified used this to the maximum amount. So if that occurs, that is a $10.4 million fiscal note. Next item we have is kind of a new program. It establishes kind of a property tax amount freeze. This is called the Homestead Property Tax Refund. Fiscal note on this item is $6.9 million in fiscal year 2023. That does increase every year as new eligible participants come into that program. It does increase into the out years. I think Department of Revenue estimated about 13 to 14 years it levels out and stabilizes. The criteria for becoming eligible for this program is anyone at least 65 years old or a disabled veteran. Your home value has to be $350,000 or less, and your income, we did have a question in calendar, I believe it's your federal adjusted gross income must be less than $50,000. Now that $50,000 does have an annual CPI adjusted to it in the out years. One thing I did point out, or want to point out, I think I forgot to do this in calendar. If you apply for this refund, you're prohibited from using the existing homestead and safe senior property tax refunds. You can't basically double stack or use both of those programs. You have to pick which one you want to utilize and go from there. There was also a provision to extend the Rural Opportunity Zone program. This came to us from the Senate, including the extension and an expansion. Their expansion provision, currently the Rural Opportunity Zone, if you move in from out of state to a Rural Opportunity Zone, you qualify for this. The expansion piece that the Senate proposed was if you live in an urban county that is not a participant in the RAWS program and you move within Kansas from an urban county into the RAWS area, you would also qualify. We felt that that wasn't a wise provision to put in there. If we need to take a look at this program, let's do it in fine fashion. Let's take a deep look at this instead of just throwing a provision in. But we did want to go ahead and extend it for 3 years just so the program doesn't expire, and it allows us to take some time and take a look at what might we need to change on this RAWS program. There's also a research and development tax credit. I still see a few people paying attention, so my apologies, but there's a research and development tax credit. This is for businesses this was actually in place and on the books. This is for LLCs, S-corps, self-proprietorships. It was on the books in 2012 when we took those entities off of income tax. This program was abolished. We're just trying to put that back in place. Some of these companies can apply for this. It's a $900,000 fiscal note. And it does not take effect until next year. We also included a disabled veterans personal exemption allowance on your income taxes. This is for veterans who have been honorably discharged and 100% disabled through military service to receive an additional personal exemption on your income taxes in the amount of $2,250. Department of Revenue, I'm not sure where they got this research, but they have 6,617 qualifiers for this program. We have 6,617 100% disabled veterans in Kansas. Do the math, that's about a $300,000 fiscal note, but we felt that this was a very impactful way to show our respect for those that have served and taken care of our country. Moving on to our sales tax provisions. First item is the agriculture fencing that was destroyed by wildfire. That was a very important bill. Early on in the session, we kicked it out. I can't remember when. It was in the first weeks of tax committee. It didn't get any movement across the floor, but it is retroactive. The premise of this was really for the December fires in north central Kansas that were so devastating to the farmers and ranchers up in that area. The Senate did change some provisions. We actually had identical bills in the House and the Senate. We passed ours out of committee clean. The Senate provision put in a few things and included a complete exemption on all agricultural fencing from this point forward. Their reasoning behind that was kind of similar to the argument on food sales tax. There are other states that also exempt agricultural fencing, and this just puts Kansas kind of back into line there. The fiscal note that I showed on that was $3.4 million. Again, that's the Department of Revenue assuming the maximum amount of usage. There's no way to know how many people on border counties are going to Missouri and Oklahoma where there's 0% tax, so that's a very difficult fiscal note to estimate, but department always does a great job. I'm always impressed with how well they do on their estimates. Moving on, we have several local, city, and county-wide sales tax provisions. For those of you unfamiliar with, when we pass the authority for local governments to impose a sales tax, this doesn't impose the tax. We grant the local community the authority to put it on the ballot. It always has to go to the local voters. Anytime you put a sales tax on the ballot, we can't do that as the state legislature. We give them the authority to ask their voters for permission. So the provisions that we had under that for Wilson County, we have up to a 1% countywide sales tax for EMS and ambulance service. We also have the city of Latham for a 0.5% general use tax. Now this one is a little bit different. They have the existing authority to place this on the ballot without coming to the legislature. There's certain limits on how much they can ask, and if they go over that limit, that's when they have to come ask for statutory authority. The city of Latham did everything right. They had all their documents provided in their testimony. They got it to the newspaper, and the newspaper forgot to publish it. So it's a small town. I think it's a weekly newspaper, if I understand that correctly. So by the time they got it in for the next week, they missed the statutory deadline by 1 day. It's a small community. We didn't want them to have to go through the expense of another election just because they missed it by 1 day. So the Latham city language is simply ratifying their request for the election that they already held legally. Next item is Shawnee County for up to a 0.5% countywide sales tax to go towards the Gage Park Improvement Authority. The Gage Park Improvement Authority is also created as an authority under the provisions of this bill, and that is to benefit the Topeka Zoo, Gage Park, and the Discovery Center. There's several provisions within the bill that specify how that money can be used, how it's supposed to be distributed, but it is a county-wide sales tax, again, for the voters to approve. If I miss anything, I'm sure my ranking member will point this out, but moving along, we have another provision on sales tax for delivery charges. Currently, if you ever order anything from DoorDash or Uber Eats or whatever the different services are out there, there's also shopping services. If you are brought those delivery or brought the items, there is sales tax on the delivery, not just the items. You're paying sales tax on all of it. And this bill just simply states that if that delivery charge is listed separately and not included in the bulk purchase and not included in the purchase, those delivery charges are sales tax exempt. We also decided to repeal the sunset on the motor vehicle rebate sales tax exemption. For those of you who've been here for a while, you've probably voted on this multiple times. We put this in statute every 3 years. It sunsets. We have to come back and vote on it. We renew it. Sometimes we haven't, but then it comes back in a few years later. Currently in state law, it's set to sunset, and we're just getting rid of the sunset. It always comes in and back and forth, so we're going to get rid of that and just make it permanent. And I believe the last item I have is new language. We talked a little bit about city and county sales tax provisions on the ballot. We have new language on there because of a situation that we were made aware of in Atchison County between the city and the county and how that income is proportioned. And we just want to make sure, so we put language in this bill that requires anytime you have a ballot question to approve sales tax, the voters need to know how that money is being distributed. How much is going to the county, how much is going to each city or taxing jurisdiction within the county, because there are apportionment provisions that exist in statute. Sometimes those aren't followed. You'll have an interlocal agreement where the city, they have a different agreement on how they want to split that up, and that's certainly okay. But the voters need to know that what they're voting on is going where they intend it to. Mr. Speaker, I will tell you one.
Sorry, did you say you were done?
I'm glad you're still awake at least. I did want to say there's a lot of information in here, a lot of provisions. The total fiscal note on this item is $90.9 million. Most of that is in the property tax relief provisions of this bill. We did a lot of work in committee trying to pare this down. When all of the requests and considerations were initially put in there, it was close to, I'm going to estimate it's about $500 or $600 million. And we trimmed it down and we trimmed it down. We eliminated some of the proposals and we actually kind of trimmed down some of the requests. The residential property tax initially was to go to $65,000. We trimmed it down to $40,000 just to try to help out that fiscal note. And we did come in right at around $90 million for all of the provisions. And with that, Mr. Speaker, I will stand for questions.
Thank you. Is there discussion? Representative Gardner.
Mr. Chairman, I'm going to go over the Democrat version of this bill. April Fools. Thank you, Mr. Chairman. Again, I can't, Mr. Chairman, you know how many bills are in this one bill?
Do you really want to know?
I believe I know.
There are provisions, if I count it right, of 29 different bills.
That's what I counted. You're right. That has to be a record for a tax bill to have 29 provisions in it. Anyway, the chairman always does an excellent job and a thorough job. The problem with, as we know, there's 29 provisions in this bill. Some are good, some are maybe you don't like. So you're going to have to figure that out and maybe make a tough vote on this. For myself, I'm going to be supporting it, but you do what you need to do. Thank you, Mr. Chairman.
Representative Helgerson.
Let's see, what time is it? Got 2 hours still. You know, I appreciate the chairman. He did a great job this year, and the ranking, they're great to work with. We had a lot of opportunity to deal with the tax issues that were coming before us. But there's a real problem out there. Now, I don't know if anybody else sees it. You know, I don't think the speaker minds. Speaker called me before the session and asked me, what do you think, Helgerson? What do you think we should do with all this money that we have? Well, how much money do we have? I just talked to JG again, and he and I had estimated somewhere between $2 billion and $2.5 billion came into us either in actual cash or projection from about a year ago to now, or when we put the budget together. $2 billion. So what do you want to do with that $2 billion? Well, I told the speaker, I said, well, I'd probably pay down debt, I would pay capers, and I'd probably put $1 billion in reserve, the $3 billion there, I'd, you know, divvy it up a little bit. That, you all know me, and I'm pretty conservative. But of those tax reductions that I talked about, we haven't had a chance on this floor to decide what we wanted. We had the Appropriation Committee come in and decide we're going to spend more money than what the governor did. Clearly more money than I wanted. But you didn't have a chance to decide where you want to put the money, whether or not it was increased money for appropriations or for tax reductions. The system needs to change. It needs to change because right now, 3 people that we send off and the leadership make the decisions about how we're spending this additional $2 billion or $2.5 billion. Now, I know in the hearts of many of you believe that we should have put more money into tax reductions. I do. I also think we should have had a larger ending balance. Next year, you're going to have a leadership race. And if God willing and sends me back here, I'm going to raise these same points at the beginning. We should not give away the authority and the responsibility to decide how we put in 29 pieces of tax reduction into how much and craft it and pass it at 9 o'clock at the end of the session. There are other ways that we can do it in a business-like way. We can put a plan together. We could budget and say, this is what our general budget's going to be. This is what the tax reductions are going to be. And this is what we can do for tax reduction. And why I'm saying all this right now is because if you checked What are we running? A couple hundred, 200, $300 million above where we're going to be? So we're going to have another $400, $500, $600 million of additional money coming in when consensus meets. And when they meet, who's going to make the decision? Is it going to be 125 of us, or is it going to be 3 of us? And are we going to give the 3 people here and the 3 people over there the authority to make all these decisions next year? You know, these tax reductions, I had the great opportunity to work with the chairman, and many of these things I have a pretty good idea about. Many of them I didn't vote for, as he knows. But you don't even have a chance to represent your district in this process. And that's a crime. Because we should come together and say, we're going to put a $8 million or a $9 million budget together, and we're going to say this windfall goes back to the people if that's what we want to do, or we're going to make a decision that we're going to blow the bank. But it is not up to leadership, and it is not up to a few people on a conference committee. It is up to the majority of us. And right now, this is the only chance we have to talk about a tax bill at the last day of the regular session at 9 o'clock at night. Man, if I ran, well, wait a minute. I do run my business this way. I make all the decisions. But if I had a corporation that had 125 people that I was as board of trustees, and I did this to them, they'd fire me the next day. So I commend our leadership for putting together this package and negotiating with the Senate. But next year, if I'm back, I'm going to start from the very first day and say, I'm not giving away this power to any 3 people in this body. And I hope that somebody will join me and say, that's exactly where we need to be. Thank you.
Representative Miller.